Hey guys, did everybody have a great weekend? Did everybody have a great Easter? Did you? Did you? Did you? I would have, hold on, I would have been live a little bit earlier, but naturally, as it would happen, this daggone school calls and says Jolie's got a fever, so I gotta go pick her up. I get there. She did look like she didn't feel good, but get her home. She don't have a fever. I checked her temperature, checked her little finger O2 meter thing. She asked for a sandwich and some juice. She ate. She's in there laying down watching TV. But good gravy, can we just have a day where she's not sick? Okay. Hey, Sherry. Hi. Hey, Margaret. I don't think she will. Mm-mm. No, I don't think she will. Hey, Spenzy. Yes, thank you. Please leave your DNA on the thumbs up button. I would appreciate it. Very big, very much, very mucho. She'll sit there with her paper towel hair and be quiet, thinking she did a good job. I know, right? She's the worst. Thanks for joining, you guys. Hey, Latanya. Good afternoon. Did you eat all your Easter candy? Did you eat all your Easter candy? Mm-mm-mm. Hope you don't get a bellyache. Hey, Morgana Banana. Hello, dearie. Let's see. Who else? Hey, Brenda. Hey, sweetheart. Lazy, but it was great. Well, that's good. That's all that matters. I know, Sherry. She coughed all weekend. She still had this cough, right? She's through with her antibiotic for the ear infection that she had. But she still has a cough that kind of got worse, but no fever. But anyway, she acts okay. She did go to bed late last night, later than she should have, but you know how it is. It's always hard to get kids back to bedtime routine, right? Thank you. I appreciate that, Brenda. Keep 'em rolling. You had Dolly Parton's chocolate decadent pie? Like, did you make it or bought it already made? I haven't heard about that. I know she has like cake mixes and stuff out, but or did you use a recipe? I'm interested. I would like to know. Oh, and FYI, you guys, you do not know this, but do you remember last week when I was talking about how I want to? Michelle, when Michelle gets in here, I'll have to say it again. But already made. Okay, nice. It sounds delicious. Anything chocolate is delicious, though, right? So, um, you guys remember I was talking about making the 0 point Weight Watcher 0 point meatloaf? I did on Friday, and it was so good. It was so good. It's a little dry because, you're using a leaner cut of ground beef, but it was still really good. Like, husband said if he didn't know any better, if I hadn't told him that I had made changes to it, he wouldn't have known. So I was like, okay, nice. Next time I make it, I'll add something to make it a little bit more not as dry, but I don't know what. Um, what was I going to say? The only thing I really switched out were 3 different things, okay? I added all the normal things, except instead of ketchup, I used tomato sauce. Just like the canned canned tomato sauce, right? And instead of crackers or breadcrumbs, I used oats, old fashioned oats. And what else was it that I did different? Oh, the meat. Instead of like 80/20 or 85 or whatever percent lean, I used 90 or 93% lean. I can't remember which. But the 90% or higher percentage of lean ground beef is 0 points on Weight Watchers. So, hey, Sherry Jones. Hello, hello. But it was very, very good. I used the normal, like eggs in it, onion, all the seasonings. So yeah, it was delicious. It was very good. Now, let me present and share the screen because court started at 2 p.m. So we will get started. Started. Okay, here we go. They're just chit-chatting at first. Lori has a little bit of a kerfuffle over a video that's being admitted because she keeps saying that the evidence says that it's the full interview, but it's not the full interview, and she wants it to be the full interview, and blah, blah, blah. And the judge is like, well, I don't know what to tell you, blah, blah, blah. So, yeah, that happens. But spoiler alert, she says she's going to rest, so she will not be taking the stand. Okay. Let's go. Let's go. All right, let me fast forward. There she is. Lord, youngins, I'm already yawning. I can't be doing that.
All right, we're on the record. State of Arizona versus Vallow Daybell, CR 2021-001-704.
I saw someone in the chat on Law and Crime said, hello, Judge McSteamy. I was like, oh. So I'm not the only one who thinks that he's very handsome.
Why don't I have the state announce?
Gabby have the state.
And the defendant?
Vallow Daybell.
All right, we met on Thursday and went over jury instructions. In the meantime, since Thursday, there was a few modifications sent out. We put drafts on your desk this morning. Last week, let me just pull up that email.
No eating reports, please.
Last week, the state requested some modifications that were made, and then on Friday, Advisory Council also requested a correction to the presumption of innocence, which I did do, as well as a mere presence instruction. Does anyone want to make a record on any of those changes that have occurred since we met Thursday? I forgot, I don't know if my staff told you, I did add, I realized standard number 9 was not added, which is defendant need not produce evidence, so I added that this morning as well. Have you had a chance to review the latest draft? Or do you need more time? We told the jurors to be here at 11, so we have time if you need more time. Any other record you want to make on mere presence?
Hey,
All right, has
Gail.
the defendant had a chance to review the final instructions?
Yes, Your Honor.
Any additions or corrections?
No, Your Honor.
All right, we're still waiting for a few jurors to show up. The plan this morning, well, let me ask the defendant, you still
Hello,
plan on
dear
resting?
Gail. Hello,
I do.
hello.
Okay, so when the jury comes in, I'll remind them that the state rested last Wednesday, and then I'll turn to you and you'll presumably say the defense rests. I'll read the jury instructions and we will break after I read the jury instructions. Depending on what time we break, I'll tell them what time to come back for the closing arguments, approximately an hour later, or around 1 p.m. While we're waiting, I had my staff email the parties about any potential aggravators. I didn't see a response to that. So in addition to, if there is a second phase of this trial for aggravation, in addition to a dangerous finding, does the state know what other aggravators it might be pursuing?
Potentially the emotional harm to the next
Anything else?
the presence of an accomplice.
Okay.
That should be it.
And in the event that happens, would you be producing testimony or evidence, or would it just be argument?
Potentially testimony from next defendant.
Okay. All right. So how many jurors? You can go ahead and print out.
Your Honor, I have two issues I'd like to bring up real quick.
Go ahead.
The jury process of the jury alternate selection, can you tell me what that process is going to be today?
It's literally drawing two numbers out of randomly out of a container.
Okay. And when is that going to be done and how does that
Not
work?
till after the closing arguments.
Okay.
So the alternates are told that they're still alternates, they're not released, because I have had in the past jurors become sick or ill or not be able to deliberate, and we have to call back an alternate to deliberate. So they're still under the admonition until they're released.
So we're keeping all of them, basically.
But only 12 will go back and deliberate.
Okay.
If one of those 12 becomes sick or is unable to deliberate, we would bring in an alternate and release the person that can't deliberate. Does that make sense?
Yes.
All right, what else?
So it came to my attention this weekend that the exhibit number 286 that the state put into evidence, that Detective Inkland testified to was the full interview is only about 21 minutes long, and the actual interview is about 55 minutes long.
Remind me what's 286 is, whose interview?
It's my interview, I guess, with Detective Inkland?
I think that's been redacted because the full interview wouldn't be admitted into evidence for the jury to review. Is that correct?
Correct.
All right.
So is it just the snippets that were played all together?
It should just be the parts that were played in court. Is that correct?
Yes, I mean, they're all connected, but
All right.
the state redacted out the beginning, the end discussions of Tylee. That would be hearsay or not.
Right. So did you have a question about that?
Yes. So is it just the snippets all put together, or is it the interview for the first 21 minutes?
I think it's just the snippets that were played in court that are put together as one exhibit.
There's connectors between all of it, but it does not include any of the beginning or the end of the interview.
Right, portions have been redacted out.
Yes,
But it's just more or less what was played in during testimony.
correct.
Does that answer your question?
Kind of, but Detective Inkland testified that it was the full interview. So what does that mean if she testified that it was the full interview?
I don't know, it's something you could have cross-examined her on, but now it's probably too late. If you wanted clarification on that, but the jury is going to know it's redacted and they get the redacted exhibits instruction as part of the instructions, so either side can point that out to the jury that it's redacted. Anything else?
I was just assuming that that might have been an error to say that it was the full interview when it wasn't the full interview, and it was admitted into, to reflect the record that it was the full interview. So are you telling me that the jury is not going to be able to go back and watch the full thing?
Your full interview?
Correct.
No, because it was never admitted into evidence.
But that's what they said was admitted into evidence.
I don't remember if that's what was said or not. I would be surprised if someone said your entire interview was being admitted, but I don't remember the
Well,
exact
my advisory
testimony.
council checked the FTR, and that's exactly what was said. That was exactly what I was shown, that it said, is this the full interview? Yes, this is the full interview, and it was admitted into evidence.
Was
So-
there sometimes they enter in the full interview for appeal purposes only, but that's not the one that actually gets shown to the jury. Was that the case?
Was not for appellate purposes, Your Honor.
Okay.
It is the full interview. The defendant talks to the detective in the beginning about Tylee, does not include that. She talks to the detective at the end about Tylee and victim services. It doesn't include any of that. She's sitting in a room for, I don't know how long while Tylee's being interviewed. It doesn't include any of that. It is her interview about what happened.
Okay. So the states closed their evidence.
I'm just trying to find out what the jury is going to be seeing. They have all that evidence in the evidence when they deliberate. Is that correct? They
Whatever
have
was,
access to that.
whatever was admitted into evidence, which portions of your interview were not admitted into evidence, it sounds like.
Okay, but from what I'm understanding from the state, just correct me if I'm wrong, it's not just the snippets that were played, but it's a partial part of the interview and some of it was redacted. Is that correct?
That's what I'm understanding. The parts regarding what Tylee said or did or didn't happen, the hearsay parts were, the start and the end were redacted out.
And then what was meant by the testimony that this is the full interview?
I don't know. I guess that's something that someone could have asked that witness. Maybe it was the full interview of your version of what happened.
So we have
There.
our Exhibit 20, the defense's proposed Exhibit 20 is the full interview. Can we replace that one with the full interview since it was entered into evidence as the full interview?
No.
Why not?
Your full interview won't come in because it's a significant amount of hearsay within that interview that's not admissible evidence.
It was admitted as the full interview.
Well, if a witness testified that it was a full
Hey,
interview,
Melinda
either
and
side
Michelle.
could have
Hey, Melinda and Michelle. Hi, guys. Michelle, did you hear what I said about the meatloaf? If not, you'll have to rewind it back. Yeah. Okay, here we go.
clarified that with that witness. I don't know what that witness meant when they said that. Anything else?
That's it.
All right.
She said,
we're
that's it.
getting the sufficient number of the jury instructions copied. As soon as
She's
that's done and our
frustrated.
jurors get here, we'll read those instructions. All right.
She's frustrated. Quit sitting crooked, Margaret. Like Brenda said, sit up straight, ma'am. She's big frustrated, man. Okay, so he's going to go get the jury instructions straightened out and copies for everybody and wait on the jurors. And looks like we're back now.
Welcome back, members of the jury. Last Wednesday afternoon, the state rested its case, so now I'll turn to the defendant.
The defense also rests, Your Honor.
All right, at this time, that concludes the evidence portion of the trial. I'm going to have my staff hand out to the jury the final jury instructions.
You know, the jury is thinking, wait, what? The defense also rests, Your Honor. The defense also rests, Your Honor.
Are we one? Oh, nope, we got it.
Something I'll
Okay.
say about her
Jurors have the instruction.
standby counsel or whatever it's called. They must not be either. A couple different things. Either they're not great attorneys because they've given her some really bad advice concerning things that questions she's asked, that kind of thing. Or they're really good attorneys who are just like, you know what, this woman is a whole piece of trash and we're here because we have to be, but we're going to let her fend for herself and I'm going to help her the very least possible that I can. I don't know which. But there's some like lines of questioning that she asked that I'm like, did you even run that by your standby counsel? Like, did you, Lori?
Much like the preliminary instructions, you can either follow along with me or just listen. I need to read these into the record. Duty of jury. It is your duty as a juror to decide the case by applying these jury instructions to the facts as you determine them. You must follow these jury instructions. They are the rules you should use to decide this case. It is your duty to determine what the facts are in the case by determining what actually happened. Determine the facts only from the evidence produced in court. When I say evidence, I mean the testimony of witnesses and the exhibits introduced in court. You should not guess about any fact. You must not be influenced by sympathy or prejudice. You must not be concerned with any opinion that you feel I have about the facts. You, as jurors, are the sole judges of what happened. You must consider all these instructions. Do not pick out one instruction or part of one and ignore the others.
Hi, Christy.
As you determine the facts, however, you may find that some instructions no longer apply. You must then consider the instructions that do apply together with the facts as you have determined them.
The name sounds very cool. Christy, a painter's daughter. I'm intrigued by your username. But hi and welcome.
Evidence to be considered. You are to determine what
Gil.
the facts in the case are from the evidence produced in court. If the court sustained an objection to a lawyer's question, you must disregard it and any answer given. Any testimony stricken from the court
Gil.
record must not be considered. Rulings of the court. Admission of evidence in court is governed by rules of law. I have applied those rules during the trial and resolved any issues concerning the admission of evidence. If an objection to a question was sustained, you must disregard the question and you must not guess what the answer to the question might have been. If an exhibit was offered into evidence and an objection to it was sustained, you must not consider that exhibit as evidence. If testimony was ordered stricken from the record, you must not consider that testimony for any purpose. If evidence was admitted for a limited purpose, you shall consider that evidence only for that limited purpose. Do not concern yourselves with the reasons for my rulings on the admission of evidence. Do not regard those rulings as any indication from
No,
me
not
of the
yet, Kel.
credibility or weight you should give to any evidence that has been admitted. Direct and circumstantial evidence. Evidence may be direct or circumstantial. Direct evidence is the testimony of a witness who saw, heard, or otherwise sensed an event. Circumstantial evidence is the proof of a fact or facts from which you may find another fact. The law makes no distinction between direct and circumstantial evidence. It is for you to determine the importance to be given to the evidence regardless of whether it is direct or circumstantial. Redacted exhibits. Some of the exhibits that have been admitted into evidence have had portions deleted from them for legal reasons. Do not concern yourselves with the reasons why some portions of the exhibits have been deleted. Do not speculate upon what the deleted portions might or might not reveal. Indictment is not evidence. The state has charged the defendant with a crime. A charge is not evidence against the defendant.
Just stopping that's pretty cool, Christy. I love that. There's a lot of us, including me, and a lot of the gals in the chat who do diamond painting. I know that's completely different than your, craftiness. But yeah, there's a lot of us who do diamond painting and really enjoy it. So Margaret's mom was an oil painter too. Very cool. Hey, Miss King. Good to see you. Good to see you, woman.
You must not think a defendant is guilty just because of a charge. The defendant has pled not guilty. This plea of not guilty means that the state must prove each element of the charge beyond a reasonable doubt. Self-represented defendant. The defendant in this case represents herself. All instructions I read to you that include references to lawyers or attorneys apply equally to the defendant's self-representation at trial. The defendant's decision to represent herself should not be considered by you when determining the facts. Comments are not evidence. In their opening statements, the prosecutor and the defendant talk to you about the law and the evidence. In a few minutes, the prosecutor and defendant will give their closing arguments and will talk about the law and the evidence. What they said or say is not evidence because it is not sworn testimony, but it may help you to understand the law and the evidence. Credibility of witnesses. In deciding the facts of this case, you should consider what testimony to accept and what to reject. You may accept everything a witness says or part of it or none of it. In evaluating testimony, you should use the tests for truthfulness that people use in determining matters of importance in everyday life, including such factors as the witness's ability to see or hear or know the things the witness testified to, the quality of the witness's memory, the witness's manner while testifying, whether the witness had any motive, bias, or prejudice, whether the witness was contradicted by anything the witness said or wrote before trial or by other evidence, and the reasonableness of the witness's testimony when considered in the light of the other evidence. Consider all of the evidence in the light of reason, common sense, and experience. Testimony of law enforcement officers. The testimony of a law enforcement officer is not entitled to any greater or lesser importance or believability merely because of the fact that the witness is a law enforcement officer. You are to consider the testimony of a police officer just as you would the testimony of any other witness. Expert witness. A witness qualified as an expert by education or experience may state opinions on matters in that witness's field of expertise and may also state reasons for those opinions. Expert opinion testimony should be judged just as any other testimony. You are not bound by it. You may accept it or reject it in whole or in part, and you should give it as much credibility and weight as you think it deserves, considering the witness's qualifications and experience, the reasons given for the opinions, and all the other evidence in the case. Defendant need not produce evidence. The state must prove guilt beyond a reasonable doubt based on the evidence. The defendant is not required to produce evidence of any kind. The defendant's decision not to produce evidence is not evidence of guilt. Defendant need not testify. The state must prove guilt beyond a reasonable doubt based on the evidence. You must not conclude that the defendant is likely to be guilty because the defendant did not testify. The defendant is not required to testify. The decision on whether or not to testify is left to the defendant. You must not let this choice affect your deliberations in any way. Mere presence. Guilt cannot be established by the defendant's mere presence at a crime scene, mere association with another person at a crime scene, or mere knowledge that a crime is being committed. The fact that the defendant may have been present or knew that a crime was being committed does not in and of itself make the defendant guilty of the crime charged. One who is merely present is a passive observer who lacked criminal intent and did not participate in the crime. Voluntariness of defendant's statements. You must not consider any statements made by the defendant to a law enforcement officer unless you determine beyond a reasonable doubt that the defendant made the statements voluntarily. A defendant's statement was not voluntary if it resulted from the defendant's will being overcome by a law enforcement officer's use of any sort of violence, coercion, or threats, or by any direct or implied promise, however slight. You must give such weight to the defendant's statement as you feel it deserves under all the circumstances. Jury not to consider penalty. You must decide whether a defendant is guilty or not guilty by determining what the facts in the case are and applying these jury instructions. You must not consider the possible punishment when deciding on guilt. Punishment is left to the judge. Presumption of innocence, burden of proof. The law does not require a defendant to prove innocence. Every defendant is presumed by law to be innocent. You must start with the presumption that the defendant is innocent. The state has the burden of proving the defendant guilty beyond a reasonable doubt. This means the state must prove each element of each charge beyond a reasonable doubt. In civil cases, it is only necessary to prove that a fact is more likely true than not, or that its truth is highly probable. In criminal cases such as this, the state's proof must be more powerful than that. It must be beyond a reasonable doubt. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty, and in criminal cases, the law does not require proof that overcomes every doubt. If, based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find her guilty. If, on the other hand, you think there is a real possibility that she is not guilty, you must give her the benefit of the doubt and find her not guilty. Evidence of any kind. The state must prove guilt beyond a reasonable doubt on the evidence. The defendant is not required to produce evidence of any kind. The decision on whether to produce evidence is left to the defendant. The defendant's decision not to produce any evidence is not evidence of guilt. Voluntary act. Before you may convict the defendant of the charged crime, you must find that the state proved beyond a reasonable doubt that the defendant committed a voluntary act. A voluntary act means a bodily movement performed consciously and as a result of effort and determination. You must consider all the evidence in deciding whether the defendant committed the act voluntarily. Absence of other participant. The only matter for you to determine is whether the state has proved the defendant guilty beyond a reasonable doubt. The defendant's guilt or innocence is not affected by the fact that another person or persons might have participated or cooperated in the crime and is not on trial now. You should not guess about the reason any other person is absent from the courtroom. Motive. The state need not prove motive, but you may consider motive or lack of motive in reaching your verdict. The charged offense. I will now tell you about the crime with which the defendant is charged. Count 1, conspiracy to commit first-degree murder. The crime of conspiracy to commit first-degree murder requires proof that the defendant, on or about July 11, 2019, with the intent to promote or aid in the commission of first-degree murder, agreed with Alexander Cox that at least one of them or another would engage in conduct constituting the offense of first-degree murder. The crime of first-degree premeditated murder requires proof that a person, 1, caused the death of another person, and 2, intended or knew that he or she would cause the death of another person, and 3, acted with premeditation. Premeditation means that the defendant intended to kill another human being or knew she or a co-conspirator would kill another human being, and that after forming that intent or knowledge, reflected on the decision before killing. It is this reflection, regardless of the length of time in which it occurs, that distinguishes first-degree murder from second-degree murder. An act is not done with premeditation if it is the instant effect of a sudden quarrel or heat of passion. The time needed for reflection is not necessarily prolonged, and the space of time between the intent or knowledge to kill and the act of killing may be very short. Elements of conspiracy. The crime of conspiracy to commit first-degree murder requires proof. 1, the defendant agreed with one or more persons that one of them or another person would engage in certain conduct, and 2, the defendant intended to promote or assist in the commission of such conduct, and 3, the intended conduct would constitute the crime of first-degree murder, and the defendant knew that such conduct was a crime. Scope of proof of conspiracy. To prove a conspiracy, it is not necessary to show a formal meeting or an express agreement. A conspiracy may be inferred from circumstances showing a common criminal objective and does not require proof that all means set forth in the charging document were agreed upon or actually used, nor that every person involved was a member of the conspiracy. Proof of membership in conspiracy. One may become a member of a conspiracy without full knowledge of all the details of the conspiracy. On the other hand, a person who has no knowledge of a conspiracy but happens to act in a way that furthers some object of the conspiracy does not thereby become a conspirator. Before you find that a defendant or any other person was a member of a conspiracy, the evidence must show beyond a reasonable doubt that the conspiracy was knowingly formed and that the defendant or another person knowingly participated in the unlawful plan with the intent to promote or assist the carrying out of the conspiracy. One who knowingly joins an existing conspiracy is as responsible as an originator or instigator of the conspiracy. A person understanding the unlawful character of a plan who knowingly encourages, advises, or assists in the undertaking thereby also becomes a conspirator. In determining whether a conspiracy exists, you should consider the actions and statements of all the alleged participants. However, in determining whether a particular defendant was a member of the conspiracy, you should consider only that person's acts and statements. A person cannot be bound by the acts or statements of other participants until it is established that a conspiracy existed and that person was one of its members. Justification for self-defense physical force. A person is justified in using or threatening deadly physical force in self-defense if the following two conditions existed. 1, a reasonable person in the situation would have believed that deadly physical force was immediately necessary to protect against another's use or apparent attempted or threatened use of unlawful deadly physical force, and 2, the person used or threatened no more deadly physical force than would have appeared necessary to a reasonable person in the situation. A person may use deadly physical force in self-defense only to protect against another's use or apparent attempted or threatened use of deadly physical force. Self-defense justifies the use or threat of deadly physical force only while the apparent danger continues, and it ends when the apparent danger ends. The force used may not be greater than reasonably necessary to defend against the apparent danger. The use of deadly physical force is justified if a reasonable person in the situation would have reasonably believed that immediate deadly physical danger appeared to be present. Actual danger is not necessary to justify the use of deadly physical force in self-defense. You must decide whether a reasonable person in a similar situation would believe that deadly physical force was immediately necessary to protect against another's use, attempted use, threatened use, apparent attempted use, apparent threatened use of unlawful deadly physical force. You must measure the person's belief against what a reasonable person in the situation would have believed. A person has no duty to retreat before threatening or using deadly physical force in self-defense if the person, 1, had a legal right to be in the place where the use or threatened deadly physical force in self-defense occurred, and 2, was not engaged in any unlawful act at the time when the use or threatened deadly physical force in self-defense occurred. If evidence was presented that raised this justification defense for count 1, conspiracy to commit first-degree murder, then the state has the burden of proving beyond a reasonable doubt that the defendant or co-conspirator did not act with such justification. If the state fails to carry this burden, then you must find the defendant not guilty of the charge. Justification for defense of a third person. A person is justified in using or threatening physical force in defense of a third person if the following 2 conditions existed. 1, a reasonable person in the situation would have believed that physical force was necessary to protect against another's use, attempted use, apparent attempted use, threatened use of unlawful physical force against a third person, and 2, the defendant used or threatened no more physical force than would have appeared necessary to a reasonable person in the situation. A defendant may use deadly physical force in defense of a third person only to protect against another's use, attempted use, apparent attempted use, threatened use of deadly physical force. Defense of a third person justifies the use of or threat of physical force or deadly physical force only while the danger continues, and it ends when the danger ends. The force used may not be greater than reasonably necessary to defend against the danger. Actual danger is not necessary to justify the use of physical force or deadly physical force in defense of a third person. The use of physical force or deadly physical force is justified if a reasonable person in the situation would have reasonably believed that immediate physical danger appeared to be present. You must decide whether a reasonable person in a similar situation would believe that 1, physical force was necessary to protect against another's use, attempted use, apparent attempted use, threatened use of unlawful physical force against a third person, and or 2, deadly physical force was necessary to protect against another's use, attempted use, apparent attempted use, threatened use of unlawful physical force against a third person. You must measure the person's belief against what a reasonable person in the situation would have believed. The state has the burden of proving beyond a reasonable doubt that the person did not act with such justification. If the state fails to carry this burden, then you must find the defendant not guilty of the charge. Use of force in crime prevention. A person was justified in threatening or using physical force and or deadly physical force against another if and to the extent the person reasonably believed that physical force or deadly physical force was immediately necessary to prevent another from committing or apparently committing the crime of aggravated assault. There is no duty to retreat before threatening or using deadly physical force. There is no requirement that any threat to the person's safety exists before the person may use physical force and or deadly physical force. However, physical force and or deadly physical force can be used only to the extent it appears reasonably and immediately necessary to prevent commission of the crime of aggravated assault. The person's use or threatened use of physical or deadly force is not limited to a person's home, residence, place of business, land the person owns or leases, or conveyance of any kind, but includes any place in this state where a person has a right to be. The person is presumed to have acted reasonably if the defendant reasonably believed he or she was acting to prevent the imminent or actual commission of aggravated assault. The person is justified in using physical force and or deadly physical force against another person, even if that person is not actually committing or attempting to commit the crime, if the person reasonably believed he or she was preventing the commission of the crime. Actual danger is not necessary to justify the use of physical force or deadly physical force in crime prevention. If evidence was presented that raised this justification defense for first-degree murder, then the state has the burden of proving beyond a reasonable doubt that the person did not act with such justification. If the state fails to carry this burden, then you must find the defendant not guilty of the charge. Non-justification for threat or use of physical force. A person is not justified in using or threatening physical force against another in response to verbal provocation alone, or if the defendant or co-conspirator provoked the other person's use or attempted use of unlawful physical force unless 1, the defendant or co-conspirator withdrew from the encounter or clearly communicated to the other person the intent to withdraw with the reasonable belief that the defendant could not safely withdraw, and 2, the other person continued or attempted to use unlawful physical force against the defendant or co-conspirator. The state has the burden of proving beyond a reasonable doubt that the defendant and or co-conspirator did not act with such justification. If the state fails to carry this burden, then you must find the defendant not guilty of the charge. Definitions. Intentionally or with the intent to means that a person's objective is to cause that result or to engage in that conduct. Intent may be inferred from all the facts and circumstances disclosed by the evidence. It need not be established exclusively by direct sensory proof. The existence of intent is one of the questions of fact for your determination. Knowingly, willfully, or knew means that a person is aware or believes that his or her conduct is of that nature or that the circumstance exists. It does not require any knowledge of the unlawfulness of the act or omission. If the state is required to prove that the defendant acted knowingly, that requirement is satisfied if the state proves that the defendant acted intentionally. A defendant is criminally accountable for the conduct of another if the defendant is an accomplice of such other person in the commission of the offense, including any offense that is a natural and probable or reasonably foreseeable consequence of the offense for which the person was an accomplice. Accomplice means a person who, with the intent to promote or facilitate the commission of the offense, does any of the following. 1, solicits or commands another person to commit the offense, or 2, aids, counsels, agrees to aid, or attempts to aid another person in planning or committing the offense, or 3, provides means or opportunity to another person to commit the offense. Act means a bodily movement. Aggravated assault means a person intentionally, knowingly, or recklessly caused a physical injury to another person, or intentionally put another person in reasonable apprehension of imminent physical injury by either 1, causing serious physical injury to another person, or 2, using a deadly weapon or dangerous instrument. Conduct means an act or omission and its accompanying culpable mental state. Deadly weapon means anything designed for lethal use, including a firearm. Dangerous instrument means anything that is readily capable of causing death or serious physical injury under the circumstances in which it is used, attempted to be used, or threatened to be used. Deadly physical force means either 1, force which is used with the purpose of causing death or serious physical injury, or 2, force which in the manner of its use is capable of creating a substantial risk of causing death or serious physical injury. Unlawful means contrary to law, or where the context so requires, not permitted by law. Jury foreperson. The case will soon be submitted to you for your decision. When you go to the jury room, you will choose a foreperson. The role of jury foreperson is important, but please remember that the foreperson's opinion about the case is not more important than that of the other jurors. The opinions of each juror count equally. The jury foreperson's responsibilities include the following. 1, make sure every member of the jury is present during all discussions and deliberations. 2, make sure that the deliberations are conducted respectfully and that all issues are fully discussed. The discussions should be open and free so that every juror may participate. 3, all jurors should be allowed to state their views about the case and what they think the verdict should be and why. 4, all members must agree unanimously on any verdict. Therefore, the foreperson should count the votes to ensure that every juror has voted. 5, if you reach a verdict, fill out the verdict form and then sign the form on behalf of the jury. 6, if the jury reaches a verdict, the foreperson will inform the courtroom assistant. When the jury returns to the courtroom, the foreperson will bring the signed or unsigned verdict form as well as any question forms that may have been used. 7, when you return to the courtroom, the court will ask the foreperson whether the jury has reached any verdict. The foreperson will respond yes or no. The foreperson is not expected to read any verdict to the court. That will be done by the clerk. Closing instruction. In a few minutes, we're probably going to take a lunch break, and then after the lunch break, you will hear the closing arguments in this case. After that, the case will be submitted to you for decision. I suggest that you discuss and then set your deliberation schedule. You are in charge of your schedule and may set and vary it by agreement and the approval of the court. After you have decided on a schedule, please advise the courtroom assistant. You are to discuss the case and deliberate only when all jurors are together in the jury room. You are not to discuss the case with each other or anyone else during breaks or recesses. The admonition I have given you during the trial remains in effect when all of you are not in the jury room deliberating. After setting your schedule, I suggest that you next review the jury instructions and verdict form. It may be helpful for you to discuss the instructions and verdict form to make sure that you understand them. Again, during your deliberations, you must follow the instructions and refer to them to answer any questions about applicable law, procedure, and definitions. Should any of you or the jury as a whole have a question for me during your deliberations or wish to communicate with me on any other matter, please utilize the jury question form that we will provide you. Your question or message must be communicated to me in writing and must be signed by you or the foreperson. I will consider your question or note and consult with counsel before answering it in writing. I will answer it as quickly as possible. Remember that you are not to tell anyone, including me, how you stand numerically or otherwise until after you have reached a verdict or have been discharged. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case. You may not use any electronic device or social media to communicate to anyone any information about this case or to conduct any research about this case until I accept your verdict. All 12 of you must agree on the verdict. You must be unanimous. Once all 12 agree on a verdict, only the foreperson needs sign the verdict form on the line marked jury foreperson. You will be given one form of verdict. The verdict form reads as follows, and there is no significance to the order in which the options of guilty or not guilty are listed on the verdict form. So this is a sample verdict form at the end of your instructions. It indicates this is a sample. An official verdict form will be given to you by the courtroom assistant in the jury room. Verdict, count 1, conspiracy to commit first-degree murder. We, the jury, duly impaneled and sworn in the above entitled action and upon our oaths, do find the defendant, Vallow Daybell, as to the crime of conspiracy to commit first-degree murder occurring on or about July 11, 2019 as follows. Check only 1, and the options are not guilty or guilty. In order to break up the closing arguments as little as possible, we're going to take our lunch recess a little early and start a little early with those closing arguments after you recess. So we'll go ahead and recess for your lunch break. If we could have everyone ready to go in the jury room at 12:45, please remember the admonition.
All rise for the jury.
All right, so he wants them back in about, what, 30 minutes from now? Okay, so okay, I fast forwarded it all the way to live, real time.
Started off with a live short driver at 5. We went into production. I took his job over when the director does everything.
Who's talking? I don't know who's talking. Oh, he wants them back at 3:45, but court is on lunch until 4:15 Eastern. That's an hour from now. Lordy day. Yeah, Kel, they usually do come after, but every once in a while they'll do it beforehand like this. Some courts do it backwards. I don't know if it's by court or by state or by judge or who, you know. I don't know. This is also one of those courts that allows the jurors to ask questions too, you know. You don't see that very often either, to be honest. We don't see that very often. I kind of like that though. You know. And one thing about that is it kind of gives you a little bit of an inkling into what they're thinking. You know what I mean? which way they're leaning. I don't know. I don't know. Mm, 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 mm. Bum, 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 bum. Susan said a while ago, I couldn't sleep last night and went down this rabbit hole. OMG, CW has a wonderful show on YouTube with Larry and Kay. Who is CW? Why am I not? I'm racking my brain. And I know when you say who that is, I'll be like, oh, duh. But right now, I can't place who that is. Right, Kel. Yeah, I like that too. I mean, obviously, you know, the judge and the attorney. Sometimes the judge and the attorneys discuss it, you know. And sometimes the judge is like, no, I'll decide whether. And then remember, there's been a time or two when the judge even asked questions after. And I think it was that judge in the one that got everybody sausage biscuits and donuts and coffee. And they had pork chops, and he was the virtual IT guy or whatever. Wasn't that Carly Gregg? I mean, even he asked questions, right? That Margaret says they would not want me to be a question asking jury.
I have 2 bags of 3/4 inches under my desk. We have one, but I'm afraid to use it. So
Brenda said, I think that's the same show I watched, Susan. I saw there was an interview with Larry and Kay, or maybe it was Kay and her siblings, her brothers. I can't remember. I don't remember. But I saw that somewhere, and I don't know whose channel I saw that on, but I've like scrolled past it a few times, and I keep meaning to put it on my, and maybe I do have it on my watch later list. I'm not positive. I can't remember. You remember, Kel? Yeah. Pork chops. Oh, sorry. Um, wait though. Wait. That was that Carly Gregg, or was that what was her name? What was the wife's name that killed her husband? Threw him in the fire pit, allegedly. But some people think the son did it. Was it that one? Okay. Okay. It was the fire pit one. Yeah, that's true. Burn pile, Melody Ferris. Patricia coming in hot. Hey, Patricia. Burn pile, Melody Ferris. Patricia wins. What was it Latanya said? Let me see. You think any of the jury questions that weren't allowed about the kid were about the kids? Because they have to be wondering. Yeah, I think so. You know it, right? I mean, I wouldn't think that they would expect to hear testimony from JJ because of his age and the fact of, you know, him having autism and that kind of thing. They may like not really think about that, about, well, why doesn't he take the stand? But Tylee, yeah, they're wondering why Tylee didn't take the stand. Mm, 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 mm. Brenda said the one I saw was with the siblings. Yeah, that's the one I saw, but I can't remember what channel it was on. Gail said I was watching Colby's YouTube Friday and my heart breaks for him. I know. Me too. I haven't stayed caught up on his channel lately either. I've watched a little bit here and there since this trial, a couple videos, but yeah, Carly shot her mom. Yeah. But I can't remember the judge. I was thinking that was the judge, but it was the judge that I was actually thinking about was from the Melody Ferris trial. Yeah, especially Tylee. He was there last week, but I don't know about today. Yeah, I don't either. This one showed a telephone call from Susan to Lori. Who's Susan? I don't know who Susan is. Susan. I don't know who that is, Brenda. We have some big things happening this week, though. Karen Reed starts supposed to start tomorrow, and then Lori's sister, Susan. Summer, you mean? Maybe she does have a sister named Susan too, but the only sister I can think of that's Lori's sister is Summer. Is not. Is it Summer? Yeah, it's Summer. Summer Shiflett. Yeah, Summer. Okay. I was like, wait a minute, who's Susan? I was trying to think who that was. But yeah, Karen Reed, Morgana, do we know, are they still on target for tomorrow for opening statements for Karen Reed? And then Stephen Stearns is supposed to have a hearing this week or next week. I can't remember which. His trial is starting soon. So that's exciting. And just a heads up, let me give you guys a quick heads up right now while I'm thinking about it. Let me see what the dates are going to be. Hold on. Calendar. Let me pull up my handy dandy calendar. All right. On April the 30th, I will be out of the office from April 30th until Monday, May 5th. So I will not be streaming on April 30th, which is Monday. So, no, I'm sorry, which is Wednesday. So I won't be streaming that Wednesday, Thursday, Friday. But I will be back streaming on the following Monday, which is May 5th. Cinco de Mayo. Because I will be out of town. I'm going on a crafting retreat. Yeah. Yeah. However, I will have a treat for you guys. I'm excited about it. So, our friend and top model, get it? Kel Riddick in the chat, she will be attending the same retreat. So I get to see her again. We've met in person a couple of times, 2 or 3 times, but we'll be together again. And I asked her already if she would want to do a live stream together with me here, throughout some of that time. So we may do that. We will do that. We just need to figure out when and about what. Like, are we going to do any kind of crime stuff, or are we just going to chit chat? We might just chit chat. I don't know yet. I don't think we'll do any kind of crime unless there's something late breaking going on, because when I do return, I think May the 5th is when Stephen Stern's trial is supposed to start for the CSAM. So, whoop, 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 whoop. We will, Brenda. I always have so much fun when I go to these retreats. For sure, Patricia. Yes, 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 yes. There's Kel. Yeah, we're going to have a good time. Oh my goodness, excuse me. We're going to have a good time. We might just do, if there's any kind of like last minute hearings or anything, I might stream that. I'm going to for sure take my laptop. I don't typically take it, but I will be this year just in case. Unless I change my mind. I mean, I can always go live from my phone. It would just be, I wouldn't be able to like share anything, like share a screen or anything like that, but I hope so, Brenda. We do. I know you missed last year. Got lots of catching up to do for sure. Kel. Christy says CW is the Commonwealth. Judge Dewey. Is that the channel name? Is CW? Let me go look. Oh, and can I just stop for a minute? Let me just stop for a minute, okay? Let me just do this real quick. I'm going to give a brief moment of silence for the Pope. I'm sure the vast majority of you guys have heard. about the Pope. My heart, when I heard that I heard it last night. It was late, or maybe it was either late last night or very early this morning. It was before I went to bed last night that I heard. Brenda, the Pope, passed away. Apparently, he died from a stroke. Yeah. I guess that the last sickness he had really, took its toll on him. I'm so sad about it. Hey, kiddo. What are you doing? Yeah, I know, Brenda. All right, I'm gonna mute my mic and you guys put your, thoughts and feelings and prayers and all of that in the chat. I'm gonna mute myself for a minute or so, just for a little brief, like I said, moment of silence. All right, you guys. Thank you, thank you, thank you. Sorry about that. Summoned all he had for one last Easter Mass. Bless him. Awful. How old was he? Do you know, Margaret? I think he was in his 80s, wasn't he? 88, okay. Ay, ay, ay. Oh, 2 years older than your mom. I wanted to go look real quick and see. Hold on, folks. I'm opening up 3 different tabs to see. Did anybody watch on the other long crime channel the bathtub murder trial? Connecticut versus Jose Morales? I have not watched any of that. Okay. I'm going to Oh, have you been watching it, Miss King? What's the story with that? What's the I mean, did he kill the mom and the baby, or just the baby, or just the mom? Like, I don't know anything about that case. Sounds awful, though, no matter what happened. I'm obsessed. I am obsessed with that tree on the left-hand side of the screen. Like, I love that little wispy willow-esque tree. What kind of tree is that? He's accused of killing the mom, and the baby has never been found? Whoa. Wild. Do they have any, like, do they think that the baby is still alive, or? Okay, I'm gonna do, I want to put this on a brief intermission. I have to go make a phone call. So I will be back momentarily. I'm gonna leave the screen on, and let you guys just people watch. But yeah, I gotta go make a phone call real quick before it gets much later in the day. So, going to go do that, and I will be back momentarily, okay? I won't turn any music on or anything, just in case they do come back random, which I don't think they will, but I know the judge said something about have them reconvene at 3:45 Eastern. So I don't know if that's just when he wants the jurors back from lunch, or so they could actually go back into the court in like 5 minutes. I don't know. Ms. King said that it's been 5 years, and from what I understood, they offered him deals if he would say where she was. He supposedly was on PCP. Ooh. That's awful. Is it like I wonder if it's like a situation where he like trafficked. You know what I mean? I don't know. For money. I don't know. Okay, I'll be right back, guys.
above all the conspiracy theories as soon as he died.
Yeah.
Do you think he just killed him?
I think it. Thank you. Stock market taking a dive again. Yeah, I think about what's wrong with one case. I did talk to we rented a taxi driver from today.
Yeah.
Luis, I gotta ask you something. I was there 2 years ago, and I met you heard about this guy we got over here. Says something to me in Portuguese. I go, that's they got out. Standard. Oh, that guy will never come back to this country. He never came through a process with it. It's amazing, and I always will say that, like with COVID and all, how educated we are medically now, how educated we become mentally. We know too much to be disinformed.
Yeah.
I would say that.
It could be hard to get through it.
Yeah.
I agree.
Have you seen the best picture of the year?
No, I haven't.
Laura? Yeah. Love it.
I know. Yeah.
You know what it's about?
Yes.
I'm still trying to figure out why the fuck this is the best picture of the year.
I haven't seen it yet. I've heard good things, but I'm like, I haven't seen it. So what'd you think of it?
Again, would I see it again? No. Definitely wouldn't see it with my wife. She never saw it. She never wanted to see it. But it's lap dancing in the first hour is like the positions of sex that you can never do. If you want, and which was amazing to me, you know where I saw it first streaming it? Disney.
Really?
Yeah, it was like, you gotta be shitting me. I know there's parental stuff on that, but some kids are gonna watch this. Oh my god. I mean, full frontal sex, everything. And then the drugs and the coke. And this lady was best actress too. Best director, best actress, best picture. And it's like, again, this is what we're doing. I think the story is that they only spent $6 million making this movie. Instead of $100 million like that. Well, not with your wife, man, I'm telling you. Turn this shit up. Unless, I don't know, but I mean, it was, wow.
Yeah, but I mean, I haven't really saw it for a long time. A lot of movies they recommend, like, they get it as art and beautiful, but
There's certain movies, I mean, we only want to see it. It costs too much. You can't pause it.
I do go more than we have home.
Right.
Me and my wife will be like, oh, we'll just go, instead of going to date night, we'll go to the movies, we'll have drinks before we go in.
Right.
Go to the movies, have a couple drinks and come out.
If you're in the biz, you fall asleep watching movies.
No.
I do.
My wife could fall asleep watching anything on the screen.
I'm bored as hell. Like, get up. Come on. You're dragging here.
I'm like, I have to finish it.
I mean, I'm at that age that even English is closed captioning. The audio is like, oh my god, I can't understand what they're saying. Even I'm watching the halftime show of the Super Bowl. Closed captioning wasn't right. I couldn't understand it. Yeah. But you have Apple TV?
We do.
I'll tell you what. Oppenheimer, great. See that? Great movie. Saw it at the theater. I had one Diet Coke. And called it a 1P movie. Couldn't get through the whole movie without 3+ hours. 2 weeks later, we go see Killers of the Flower Moon.
Yeah.
That's 3 hours and 45 minutes. I have my Diet Coke. No tea. I was so wrapped up into this movie. I was like, dude, it was eye-opening. You've seen the movie. It's a tough movie to watch. It's about the Indians, the land that they had, and stuff like that. Nero was in it. Nero was great. Absolutely spectacular. Leonardo's Leonardo. Yeah, he's good, but De Niro, but that movie was like, oh my god. But I don't think I would pause it at home. Theater, you're forced to watch.
Yeah.
No doubt. I mean, I went
Okay, I'm back.
Jason Bourne.
Oh, yeah.
My wife and I went to the movie. I fell asleep.
Get the volume back up.
Because of the quick cuts.
Yeah.
Sorry about that. I had to make a call, and that person might call me back.
And all of a sudden the sheet was above my head.
So if they do, then I'll have to bounce again for a couple minutes. But anyway,
I take it when the movie Titanic came out. Alright? Leonardo's not even on the boat yet.
make sure I got my phone on. Okay, I do.
Theater's packed. Second day it came out.
I'm ready for these closing arguments.
I don't think they're going to change the plot.
Michelle says, have I missed anything? Got word Mom's MRI shows she has had. Oh, Michelle, I'm sorry.
Here's the iceberg. She starts kicking the chair in front of her, and the guy who's sitting in front thought it was a kid. He turned
I'm
around.
sorry.
Dude, ma'am,
Like recent, or was it like an old one, an older stroke?
I don't know if you're like my wife. We had home watching it. Thank God.
Ugh. And how is husband,
You know? Or, what'd they say?
Michelle? Because last I knew, he may have been going to the emergency room for appendicitis. And I wondered how he's doing. Donnie, I know, honey. We mentioned it a while ago and had a brief moment of silence. And, yeah,
And I'm not even.
I'm sad about it.
How I look. You look great. Yeah, really. Yeah, really. What do you think about my toenails? Yeah, they look great. I mean, I always start with the toes and work up myself, all right? So I can tell people I'm so old.
Why are these men talking about their
But I can't
toenails?
say that too loudly, all right? I've done comedy from shit like 3 and 5 minute pieces. But I think, like I said, if I repeat myself, don't just let me go. I tell people my wife's done every one of these.
Hold on, I gotta turn the volume up on this.
Don't understand.
Let me rewind it. Hold on.
Well, like I said, she's a competitive rower. And she... It's 2 words. But I can't say that too loudly, all right?
Hold on.
I don't think they're going to change the plot in this movie. We have an idea what the hell's going to happen. It's like... It hits the iceberg. She starts kicking the chair in front of her. And the guy who's sitting in front thought it was a kid. He turned around and goes, "Excuse me, ma'am, Jeez. But I hate that. I don't know if you're like my wife. We had home watching it. Thank God. You know. But what do you think's going to happen? I don't know. I mean, I haven't seen it either. You know? Or, what'd they say? Oh, let me back it up. I mean...
It is the same thing with the. I'll watch the same thing. I know it's going
Yes. It's called total surrender.
Yeah, pretty much.
Yeah, yes, honey. That's the translation.
So cute.
Yes. Oh, God. And I'm not even. What do you think? How do I look? You look great. Yeah, really. Yeah, really. What do you think about my toenails? Yeah, they look great. I mean, I always start with the toes and work up myself, all right? So I can tell people I'm so old, I remember when harass was 2 words. But I can't say that too loudly, all right? I've done comedy from shit to fucking 3 and 5 minute pieces. But I think you could, like I said, if I repeat myself, don't just let me go. I tell people my wife's done every one of this one of it, me and married me. She tells it because she took on the team. I don't know that shit at all. I don't understand that shit. Well, like I said, she's a competitive grower. And she's 73. She's coaching now. I wrote for coffee. I got into it because obviously I need to exercise my jaw. She would come out and I don't know what we're talking about. And I had to be quiet at dinner. I better learn this sport. So I learned how to do it.
Gross.
So now we have conversations. Don't leave this. This is a no-no at the dinner table. But it's amazing when you go out there and see colors.
Hey, Ween baby.
Wow. You got any kids?
I got grandkids. Yeah, I got a
Right on,
30-year-old
dude.
and a 27.
Right on, right on.
10-year-old and 6.
That's the regret I have in my life. I never had a kid. My wife had her.
Oh, I'm glad, Michelle, that he's feeling better.
I call grandkids, but I'm not blood. It's that bullshit. I'm not blood, so I'm just Steve. That's all I am with these kids. And they, right, I was there.
Mm-hmm.
Me and her had a fallout with stepdaughter. So I got her at 12. She was 12 years old and her dad died. So I was taking mom over. And that was part of it. So I would come up to her and she would come down to my attitude.
Yeah.
So, but anyway, now she realizes she's 40 years old. She realizes that she doesn't have to worry about her mom. But still, there's friction.
I don't know
But again, that's the regret. Power to you, do what you have to do.
who this Joker is, but
Try.
Yeah, that's all you can
Gotta
do.
do your best.
That's what you can do. I
Yeah.
always try to say, don't let the four-letter curse me bite you in the ass, kids, all right? Time is to let that bite you. You can do whatever you want to do. Try to find something that you love to do.
I know. My kids have not gotten there yet.
They will.
Yeah.
Like I said, you don't put pressure on them, they'll figure it out.
They, actually, I think both of them would have done great in this industry, but they, they didn't like the hours. It's not good news to them.
There you go. There you
And
go.
they, they grew up, in my opinion, it was influence.
Yes.
So both of them were like, no. So now they're really good. I said, it's not. It's not. It's just
Yeah.
and now they're like, pretty interesting. Try to pay this.
Yeah. I mean, my dad was an airline pilot. Thought I would be getting into that.
Yeah.
And I went to college for aviation, right?
Lord.
Mom and dad did
Just
nothing.
random chit chat, right?
Dad said, son, you think you're good, obviously, as the beer garden.
Random
I don't know
chit
why
chat.
that VHS thing in high school was pretty cool. What do you need to do there? I go, nothing. I'm 20 years old. I get a first class license in communication. I go back to school. My mom, very resourceful. She's on a very resourceful.
Yeah, hang in there. Sherry says, hang in there, girl, talking to Michelle.
First class license. What do I do now? Make up a list. I got no experience.
Okay, I'm done listening to their
You just leave it up, send it out to gift, and then you're gonna sell it.
their
Nowadays with Indeed and ZipRecruiter,
man chatter, their man talk.
you gotta whoever's on it, go delete. Oh, check her out. That's how it works. And I tell these kids, you need an internship. You're in school. What you want to do is call the place you want to get.
Oh, Donnie. Yeah.
And say, listen,
I don't know. It's like there's like this man code where they can die. Who knows? They kill me. And you know how a lot of times you'll have that like that like co-worker mentality where they can just shoot the crap with their co-workers. They kill me. Men kill me. But you know what? Women are awful too. So, I mean, you know what I'm saying? Look at some of the stuff we talk about over here. Let's just be honest, right? Um, throws Michelle 2 Pepsis and a big hug. Aw, that's sweet.
Learn my way. Once you learn my way, you're going to come back to me. Can we try it this way? There you go.
Yeah.
That's the deal.
You are not an angel, man.
Every generation brings it up. That's the secret with this biz, or any biz. That's why I told you what's the best thing about live TV. It's over. It's life in general. You make mistakes. But we
Right, Donnie. Yeah. What does that saying? Ignorance is bliss or something like that.
I know, man. It's funny that
That's a fact, Ween Baby. Yes.
right.
And it's not supposed to be like that. You know what I mean?
Stop slow. Exactly.
it frustrates me. I'm like, oh,
It's not supposed to be that way. Older women are supposed to
Well, I had remember working with the Sons and I did a music video for this one guy.
mentor younger women, right? That's what they're supposed to do. Yeah, I believe that. I believe that.
Whatever. And you never tell them that you did that because I've heard a friend of mine.
How am I throwing you under the bus, Morgana, by saying you're not an angel? You are not an angel. You are not an angel. She's like that little angel that's like, whoa. You know, you have that little angel that sits on your shoulder, and then the little devil that sits on your shoulder over here. That one will be Morgana right over here.
30 frames per second. Very
Yeah.
good.
Said that you're an angel, Morgana? Your mom did?
So you do mostly afternoon or morning?
Young women usually don't want to be mentored. Well, that's true. But there comes a time when they change their mind about that. You know what I'm saying? Usually. In most cases I've seen, when young women don't want to be until they hit a certain age, and then they're like, okay, I need some real life advice. Ween Baby says that I'm 41. I'm like a full-grown woman. I'm not 20 anymore. I guess I look a lot younger. You do look young for your age, honestly. Oh, Donnie, no. No. Massive storm on Saturday. Some people still don't have power. Do you have power?
And I go, yeah, well, that's how's Birmingham. Oh, it's great, but I got to tell you something. We're going to switch from CBS to Fox. How do you think they're going to take it? I went, oh my God, I think people are going to be shocked. And then every station changed except channel.
Morgana said she said my halo slips every once in a while, but I'm mostly an angel. Okay. Well, there you go.
I remember for me it was, I didn't really,
Sherry. Sherry says, yes, Morgana is an angel. Okay, well, if we're coming from the perspective where we're talking about Morgana and Sherry, Morgana is the angel and Sherry's the little devil. Ween Baby, so where I work, they expect the youngins to be perfect, like they haven't been doing the same job for 20 years. You do, but
Now
your
you
dad's
gotta
is
have
still
fake
out.
passes
Ugh.
and everything now.
Sherry's like,
I used to love them feeding us everywhere we went.
Mm-hmm.
That's like,
Well, you've been to the Suns games. Their press room has changed.
the other Sherry's like, oh.
Oh, the food's amazing. Lamb chops, steak. Oh, man, you gotta get yourself on there. Now, it's funny when the Suns aren't
Oh, I love picking on you guys. I love picking on you.
I was the filling guy when guys couldn't
Oh, Sherry, right? She said she ate too many deviled eggs yesterday. There you go. Oh, wow, Ween baby, that's crazy. Storm lasted less than 5 minutes, but had 100-mile-per-hour straight winds. It did tons of damage. Oh,
I worked under Janet Huber, Chris Ang, Mama Janet.
Chris was flying in Oklahoma yet Saturday. They had to divert because of tornadoes. Wow.
Started at Fox, which was the cool new young station.
Yeah.
So I got to learn under all those guys. I shot like Gannon with all the switch.
You really?
So that I'm trying to backpedal? Mama. Right, Morgana, talking about me. Mama. Hold on a minute.
I know they offer for everything.
Mama. Mama. She threw me from the train. What is that movie, Throw Mama from the Train? Mama threw Jenny from the train and ran over top of me. Oh my gosh. She said, what? I love that. Your mom is the best. She's the funniest. She's so funny. She's so funny. We had great weather over the weekend. I was shocked over, I mean, we did have quite a nice little storm ourselves on Saturday, but nothing damaging. However, the rest of the day and then on Sunday, the weather was great. It was supposed to rain all weekend, and then they all of a sudden changed their mind. We ended up doing our Easter egg hunt on Friday because we thought it was going to pour the rain on Sunday, and then it did not. So she's over here talking to you like you can hear her. I love that. I love it. Mama, do me a favor. Morgana's mama, do me a favor and give Morgana a little smack on the behind for me. Can you do that for me? A love pat on her behind. Yum yum coffee. I actually think I'm gonna make another cup, but I'm gonna let it cool and then put some ice in it and make me an iced coffee. That's what I think I'm gonna do. Yum yum yum. I haven't had an iced coffee in a while. Hey, Cynthia Boudreaux. FYI, those willowy trees are willow acacia trees. Well, they're gorgeous. I love how wispy they are, you know? She said I'd love to, like a creeper. Yay! Oh, you've been lurky lurky. That's good. Good, good, good. Good, good, good. Michelle, you're usually the one throwing those things into the chat. Their chat's gonna have to throw them out to you now.
I never retired. 2019 was the last one.
Right?
Oh, really?
Having benefits, yeah.
I guess everybody.
And freelancing was at first was
I bet the one dude is like to the other, like thinking in his mind to the other dude, like, dude, I wish you'd shut up and move along. I'd be like, sorry, I have to go call my wife. I have to go do something on my phone. Does he work with him, or is it like just a passerby? Like, did the dude go to the courthouse to pay his like property taxes or something and just stop to talk to this random cameraman? Like,
so I did that for a while, then I got back into
I'm confused.
freelancing, spring training, Grand Canyon. I do every game. Sit in-house, this way I don't have to build the show, table it.
I feel like it's a different version of what was that TV show they used to have on TV years and years ago where the taxi driver would have a camera on, but the folks in the back seat didn't know that they were being video recorded. What was that TV show called? I can't remember what that was called. Oh, Lord, this is taking forever. Oh, wow. I must have been behind for a couple seconds. La-di-da-di, me likes to party. I don't cause trouble. I don't bother nobody. Dun 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 bum 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 bum. It is 4:15, so they should be ready for their closing arguments any second. Any second. I feel like Lori's just going to use her closing argument as her, like what she would have said on the stand. You know what I mean? I feel like that's what she's going to try to do. Her narrative. Because in her mind, she's thinking, let me just do it that way so that they don't get to cross-examine me on that, on my closing. Right? Camera's moving. I think we're ready. Here we go. Here we go. Here we go.
That's fine.
There's
All right,
handsome
we'll go on the
judgy
record.
judge.
State of Arizona versus Lori Daybell, CR 2021-001704. Before our break this morning, the defendant moved to have an exhibit admitted for appeal purposes only. That exhibit number, the correct number, I believe, is 269.
That's what I understand, Your Honor.
All right, so it's ordered that 269 would be admitted for appeal purposes. It won't go back to the jury during their deliberations. Go ahead and get the jury lined up, I guess.
Bring the jury. I'm super sleepy all of a sudden. Snore City. Snore Central. That blonde woman sure is whipping her hair around like she means business today. I know, Sherry. I would love to have a cup of regular coffee, but I have to drink decaf. Because I've found out that regular coffee makes my blood pressure go whoop. So,
All right, the jury's now present. Please be seated. This is time set for closing arguments. The state can proceed with its closing argument.
hey, here we go.
July 18th of 2019, just 7 days after this defendant and her co-conspirator Alex Cox shot and killed Charles. This defendant texted her soon-to-be next husband, Chad Daybell, about Charles's life insurance policy. Her words tell us that she was involved in this killing. Her actions and her words of texting Chad Daybell tell us the motives behind this murder: Chad and money. The morning of that 18th of July, Lori Vallow texted Chad and said, quote, "I just got the letter from the insurance company saying that I am not the beneficiary. It's a spear through my heart. Who do you think he changed it to?" Later that day, after she spoke with the life insurance company, she sent Chad another text. Quote, "So I talked to the insurance company. He changed it in March. Probably it was Ned before we got rid of him." Lori Vallow's words 7 days after Charles was shot and killed tells us that we was her and Alex killing Charles. Why? For that money. But Lori Vallow's plan to kill Charles wasn't just known by her lover, Chad Daybell, and her accomplice and co-conspirator, Alex Cox. It was also known by her brother, Adam. Adam told us that he knew about Lori's beliefs. He knew what she had been saying about Charles's concerns for himself. And he told us that he knew about this plan for an intervention, to talk to a stakeholder. That morning of July 11th, when Charles arrived at Lori's house, as she knew he would, he texted Adam and said, "Al is here." Adam texted back, "They are planning something." He knew. And 3 days later on Saturday, when Adam finally learned, when his friend Googled Charles, that he had been shot and killed by Alex, Adam told us he went back and talked to his mother and he confronted her about this. And he told his mother, Lori and Alex conspired to kill Charles. He knew, and he was right. Lori's ex-friend, Christina Atwood, she told you about that very uncomfortable dinner on June 9th, a month before the murder, where Alex Cox was talking about just wanting to kill Charles. He said this multiple times, and this defendant didn't care. In fact, she talked about how she had been drugging Charles. Christina told you she was so disturbed by this, she actually went and saw Lori the next day, June 10th, and told her, if something happens to Charles, I'm going to have to go to the police. Christina knew. She was right. And Nancy Jo Hancock, now she had just met Charles a few days before, and they had talked and texted and had been on the phone for hours, you heard. Charles had told her all about Lori, the things she was saying, the things she was doing. She told you that she knew that Charles was concerned for his own safety. And she understood the motive. She told Charles the night before, you probably should just tell Lori that you've changed the beneficiary, that she's no longer going to get that money. Nancy Jo knew, and she was right. Lori Vallow wanted the $1 million, and she wanted Chad Daybell. And she and Alex used that twisted religious beliefs they had so that they could kill the evil, possessed Charles and be like Nephi. The evidence that has been presented in this trial will prove to you beyond a reasonable doubt that this defendant is guilty of conspiracy to commit first-degree murder. So I want to split up my closing into 3 sections. First, I'm going to talk to you about the timeline and the motives in this case and the evidence that supports those. Second, I want to talk to you about the jury instructions and the evidence that's been presented to you in court. I'll remind you that anything the defendant said in her opening was not presented at trial through a witness or through an exhibit, and it is not evidence. Using the evidence that has been presented and admitted at trial, the state will show you how, again, the defendant is guilty beyond a reasonable doubt of this crime. And finally, I'm going to talk to you about those justification defenses, the excuses and the reasons why the defendant would like you to believe that they had a valid basis for shooting and killing Charles on July 11th. And we'll talk about how, in fact, there is no justification for what they happened. What happened that morning was a first-degree premeditated execution of Charles Vallow. So let's go through the evidence. The timeline really starts, and we know it goes back much further than this, but the big change occurs on June 29th or 30th, when you learned that Charles Vallow learned about these KK Walker emails. He learned about that affair with Chad. Now he knows Lori is cheating on him. We know that he contacted Chad Daybell about it. He contacted Chad's wife about this. He told Adam about it, and he told the defendant about it. So everyone knew that Charles now knew this. July 9th is now the first time that Charles is going to be coming back to Arizona. We know from the time he learned about that affair, he hadn't been back until this planned visit to see his son, JJ. We know at 1:13 p.m., Charles texts Adam and books him a flight for the next day. At 1:21, we know that Adam is contacting Alex. And they talk for 20 minutes. And Alex lets Adam know, sure, you can stay with me. Of course, Alex doesn't know the plan yet, the mission. Lori then starts talking to Chad Daybell. We know that she knows about this intervention. She knows about Adam coming, and we know this because, again, of her text messages. We see Lori then starting to round up the troops. Why does she do this? Because she wants to ensure that on July 11th, it is Charles and only Charles coming to the house and not the intervention of Adam or Brandon or Zach coming over to help him. So she has Melanie. Tells her she can't go to this wedding. She has to stay here. It's coming to a head. This week will change everything. Call me. Then we have July 9th, the text messages with Alex. She tells him, so the plot thickens, call me when you can. He doesn't call her initially. So she sends him another message. This one really letting him know. She specifically tells him, I'm going to need you to stay close to me the next couple days. Mel too, she can't go to Utah. She's got a job. They are planking some kind of intervention, but want Mel out of the way, so I'm left alone. She talks, I need to come get the stuff at your house tomorrow and secure it. Lots to do. Thank you for standing by me. It's all coming to a head this week. I will be like Nephi, I am told, and so will you. And then what happens? This gets Alex to call, and they talk for almost an hour. An hour planning how they're going to stop the intervention, how they're going to be like Nephi. As we get to the 10th of July, and we continue through this timeline, we see Lori again talking religiously with Chad. 149 minutes that morning. She's also texting Melanie Boudreaux, Melanie B, telling her that it's important for the mission, for Melanie to help her by keeping Brandon distracted. And we saw those messages where Melanie says she'll pretend to be sick. We know that on the 10th, Adam arrives in Phoenix. And now we have Summer helping the defendant, letting her know what is going on with Adam and Zach. Everyone is covered to ensure that Charles will be alone on the 11th. We have the continuing talks with Chad, her soon-to-be husband. As we get into the 10th in the afternoon, we know that per their agreement, Adam calls his brother Alex. Hey, I'm here. Brother doesn't answer. He sends him a text. I'm here. No response. Why? Because the night before, his sister Lori told him, we have a mission. We must be like Nephi. Charles is coming into town. You must stay at my house the night of the 10th so you can be here the morning of the 11th. We also know that Summer gave Lori an out. Hey, you can stay at my house. No one will know where you are. We're going to be out of town. You can hang out here. Lori doesn't take her up on that. She has a mission to do. As the night grows on the 10th, Adam continues to try to reach his brother Alex. Again, no response. And by 45 or so minutes after that last text by Adam, we know Alex is already at Lori's house. He's there with his gun and a garbage bag of some underwear. Why? That gun is important. A loaded weapon, 2 extra magazines of ammunition with him. He is ready for his mission. And again, Summer is updating her, telling Lori that Zach and Adam are still at her house. They're going to go stay at Mimi's. And she even tells him that Adam is still waiting for Alex to get back to him. Still, he doesn't understand. Why isn't my brother responding to me? I was supposed to stay there. And again, what does Adam bring over? A gun and a garbage bag of clothes. That's all he needs to be part of the mission. When we get to July 11th, we still have Lori talking with Chad. We see those text messages going back between them. And then we start learning from the GPS from Charles Vallow's phone as he arrives. 7:35 a.m., he arrives at 5531 South Four Peaks. That's where we have at 7:36, Adam texting Charles. They are planning something. There is no reason why Alex should be there. And that explains why Alex wasn't responding to me and didn't let me stay there. We see that last outgoing text message by Charles Vallow at 7:37. And in fact, what we see is at 7:37 and 12 seconds, Charles sends out his last outgoing message. And at 7:37 and 29 seconds, there's an incoming message from Adam. It's not read until 12:13 p.m. What becomes important here is in this timeline, how long is Charles at the residence here? You hear in her interview how she says it's so fast. Charles comes inside. He's angry. He's jerky. And she tells him, take JJ. Go get him Burger King. They get JJ out to the car. And then she holds onto the phone. And this argument erupts, and it's just so fast. But what we know is it's actually 12 minutes long. This is not a fast incident. In this 12 minutes, Lori Vallow and her brother, Alex Cox, are doing their mission, and they are being like Nephi. We know at 7:49, it's over. Lori has left in Charles Vallow's car with his phone and JJ and Tylee. We know that there are 2 phone calls between Alex and this defendant after she leaves. As Charles is laying, dying or dead on the floor, 7:52, 8:06, they talk. 47 minutes passes before Alex calls 911. 47 minutes to stage the scene. The police are advised when they arrive that the shooting just occurred and that CPR was given. Why is that important? Because you heard even during the interviews, the police were trying to figure out this timeline. Didn't make sense. At 8:48, almost an hour later, Lori Vallow returns. And then we see that around 9:40, she is being interviewed at the Family Advocacy Center. We know that Lori Vallow has Charles's phone that entire afternoon. You saw the PowerPoint from Detective Werther showing that her phone by about 12:36 is already her phone, Alex's phone, and Charles's phone are all in the area of Alex's house out in Sandham. You see on her records that she, again, calls Chad Daybell. We see that Detective Enclan calls her and leaves her a message. They don't leave immediately because what do we know? We know at 2:13, Alex is taking photos of Adam's flight reservations from Charles's phone. not screenshots, but photos of the phone. At 2:18, Lori Vallow, who has not told Charles's kids, his family, about his murder, is calling the mortuary. A little bit after that, they still haven't left. She's calling Chad again. And then by 3:11, we know that Charles's phone, through the GPS data, is back at 5531 South Four Peaks. And when asked about it, the defendant and Tylee hand it over and provide the PIN. They have no problem on how to get into it. They've already looked through it. They don't need it anymore. That evening, Lori and Chad are talking all night. You can look through the exhibits and see the multiple calls of them discussing. These aren't calls to Charles's family. They're not calls to his kids. They're talking with her lover, her soon-to-be husband, Chad Daybell. So let's talk about the motives of this case. Money. We see that from the text messages and the anger that you see through them when she learns that that's been changed and she's not going to get it. Chad Daybell. We didn't go through those text messages, but you can look at them. They are already very romantically involved by the time that Charles is murdered. And it's clear that Chad knows exactly what's going on because he's asking her about the car, about the insurance. All of those things Chad knows. And then there's that religious belief system. The zombies, the Z's, the possessed evil spirits. And her being like Nephi. All a reason and a way to kill someone, just like Nephi, a justified killing. There's that first call when we talk about money motive to Banner Life Insurance.
And what was the cause of his passing? Well, he was shot. Okay. So I don't know how I want to put that. Okay. All right. And I hate to ask, but is it? Yeah, you can just say yes or no. Was it a homicide? No, it was an accident. An accident.
So what we hear here is Lori Vallow being untruthful to Banner Life Insurance. We'll talk about credibility later, but it becomes very relevant that even in the smallest of things, this defendant exaggerates, minimizes, and is completely untruthful to various people. We all know that she was not the beneficiary. She didn't. But we also know that Charles Vallow was not accidentally shot. She told the police she was there. She knows that her brother intentionally shot him. Of course, they want to claim it's self-defense. There's no accident about that when you shoot someone twice. Motives for money. What we see again here is Lori Vallow talking to Chad about the motive. Telling Chad about the fact that it was changed. I just got the letter from that insurance company saying I am not the beneficiary. It is a spear through my heart. Who do you think he changed it to? Brandon? Or probably Kay? He left nothing for JJ. What do we know? Again, we see that Chad knows about all of these things. And what does he talk about in that morning as you have those entire messages in Exhibit 230? It would be interesting if he got changed after he had 2 bullets to the chest. Again, as we talk about the murder, we have later in that day the message that I talked to you about. So it was probably Ned before we got rid of him. We, not I, not my brother Alex, but we did. And then the other thing in this text message that is of importance is the fact that Lori Vallow knew a month before she went to Social Security how much money she was already going to get for the death of Charles. Here she says, I will still get the $4,000 a month from Social Security. When we talk about that motive and the anger by this defendant over not being the beneficiary, we know that even on July 28th, so 10 days later, she goes into Charles's computer to find the change of beneficiary form. She texts that to Chad to show him, and she sends it to Kay and confronts her about it. Money. That's what she wanted. And Chad. So let's talk about Chad, the affair with Chad Daybell. We know that she knew him as far back as November of 2018, when he came to Arizona and stayed at Lori's house. You were told by Detective Duncan that there were recordings on her Lori for Style iCloud account of Chad Daybell here in Arizona for that Preparing the People conference. You also heard that in the Lolly Time, the later account that was created later, that in March of 2019, there were screenshots of flights to Idaho and back to Arizona with both Lori Vallow and Chad Daybell. This is during that time when she disappeared and Charles was taking care of JJ, and she's off flying to Hawaii and Idaho, living the good life with her soon-to-be husband. And then, of course, we know that come November 5th, she actually marries Chad Daybell. That KK Walker email address, this was that June 29th, big change. What do we know? That on April 21st, she created that account. She used her own phone number in creating it. And then she sent messages to Chad Daybell, brother Daybell. You have that exhibit. She pretends to be Karen Walker and invites him to Houston, because that's where she is at that time. She offers to use Charles's money to fly him out there, and that he can stay at the house with her and her husband. In June of 2019, we see that Lori again uses that same account, but this time she pretends to be Charles and invites Chad out to Arizona to help him with a book. And again, in Exhibit 289, you have those letters. Charles finds those. And he lets everyone know he did. And he confronts Tammy, lets her know. Confronts Chad, lets him know. And he certainly lets the defendant know that he knows. And now the jig is up. We see in these text messages that were recovered from the iCloud accounts, whether they're under the Bubby context or under the Melanie 2 contact, this relationship between Lori and Chad. If you want to read the story, it kind of mimics them meeting in November, hooking up in hotels, and discussing their love for each other. When we are talking about a motive and a person who wants money and who has not worked for 13 years, who has had her husband pay for her homes, her phones, her cars, allowing her to go to the temple and work out and go to lunch in restaurants. This is a big change in life if she loses all of this. But if she gets $1 million, it's not so big of a difference, along with that Social Security she'll be getting. And then obviously we know that once Charles was out of the way, Lori and Chad were able to get married. But what about those religious beliefs? Everyone that Lori knew, who she expressed them to, told you that they were not in line with the Church of Latter-day Saints. Everyone told you that she said things like she didn't need to repent, she didn't need forgiveness, she could do whatever she wanted now, that she was in a celestial state, translated, that she is spiritually and physically changing, that she's above the priesthood, that she knew who was dark and evil. You saw those text messages, both about Charles and heard from people, as well as about Brandon and Zach and Adam. People who were helping Charles were also dark or Z's. And ultimately, what did we learn? That she associated herself with Nephi, a prophet, a holy man, who was justified and asked by God to kill Laban because he was an evil, wicked king who had the tablets that God wanted him to go get. Lori was just like that. She was justified in her killing. We heard from her brother, Adam, that their relationship had ended when she told him some things about her beliefs that he disagreed with. That she was turning into that celestial state, that she didn't need to eat, that she had more authority than the priesthood.
Yes.
You yourself personally, were you aware of Lori having outside? Lori having any beliefs that were outside of what is accepted by the LDS religion?
Yes.
Can you tell us what you were aware of that you knew to be outside the LDS religion?
Lori told me that she was in the process of translating from a mortal human being to an immortal human being, a celestial state.
That's something that the LDS religion supports?
I haven't heard of it that it's happened here on Earth yet.
Serena Sharp told us about, again, the not repenting and Lori changing physically and spiritually.
Members of the LDS Church?
Yes.
During this time, did Lori ever tell you things about her beliefs that seemed to go against what you understood or what you were taught through the LDS Church?
Yes.
Did Lori ever tell you that she did not need to repent?
Yes, she did.
During this weekend, did Lori talk to you about her husband, Charles Vallow, being possessed?
Yes, she did.
What do you recall about her talking about her husband being possessed?
I recall that she spoke about her husband being possessed by an evil spirit, and she named the evil spirit.
Do you recall what the name was?
Yes.
What was it?
It was Ned.
N-E-D? Ned?
N-E-D.
Now, Serena Sharp was someone who met Lori in November, texted or talked with her for a while, and then was invited to that girls' weekend. One of the jury instructions you're looking at, and we'll talk about more, though, is the credibility of a witness. Serena Sharp has no dog in this fight. She knew Lori for a little while. She was invited to, I'll call it the inner circle. The defendant told her some things that went against her religious beliefs, and she said pretty much after that the defendant stopped talking to her. Now, how do we know she's being truthful? Well, we see Ned in lots of text messages. This just helps tell us that this is something Lori was telling lots of people, that her husband is possessed by this evil spirit, Ned. And we learn later that, like Nephi, she can get rid of him.
Do you recall Lori Vallow telling you that her husband Charles was no longer Charles, that he was now this possessed person?
Yes.
When Lori was talking to you about Ned, was she explaining that this evil spirit was now in the body of her husband?
I don't know if she used those exact terms, but that was the impression I got, yes.
So the word she used expressed to you that idea that this evil spirit Ned was now in her husband's body.
Yes.
The other thing that Serena Sharp told us was Lori using that term zombie. You remember how upset the defendant got by her saying that. But again, why would Serena make up any of this? She has no reason to. What she recalls is that that is a term that this defendant used when speaking of people like her husband who were possessed by these evil spirits. We heard from Christina Atwood as well, the same concept that Lori Vallow repeatedly would say.
Did she tell you, as well as the other women who were at this meeting in February, that her husband was possessed?
Yes.
Okay. So it wasn't just you in a private conversation?
Correct.
She was open about it?
Yes.
So again, we see this ongoing timing of Lori Vallow talking of her evil, dark husband, who she later is authorized under her religion to get rid of. We know as well from Christina Atwood that there is a progression of these beliefs becoming more deviated from the LDS religion as she is meeting with her between February and June when she finally hears those words.
From the time you started meeting with these gatherings in February through to June, did you start to see sort of a progression of things that Lori was telling you that seemed outside of your faith?
Yes.
Did she make statements to you that you believed went against your religion?
Yes.
Did she at any point tell you that she did not need to repent anymore?
Yes.
What is that meaningful to you in your religion?
We believe that every single person outside of Jesus Christ has reason to repent.
Other than Lori Vallow, according to her words to multiple people. So let's take all of this, the motives and this timeline now, and talk about some of the jury instructions and all the evidence that supports proof beyond a reasonable doubt that this defendant is guilty. I want to start with talking to you about direct and circumstantial evidence. You have a jury instruction that tells you that evidence may be direct or circumstantial, that direct evidence is the testimony of what a witness saw, heard, or otherwise sensed, and circumstantial evidence is proof of a fact or facts from which you may find another fact. You're told the law makes no distinction between direct and circumstantial evidence. And this is relevant. The witnesses have often been questioned. Did you see, hear, or do that? What you are told is you can actually use circumstantial evidence to convict anyone. But let me give you an example of this. Imagine you are sitting on a beach. Just you, it's quiet. Off to your right, there's some rocks and you can't see around that. While you're sitting there, a person walks by, you watch them walk by, and they go around the rocks and you can't see them anymore. And then someone runs up 5 minutes later and they say, hey, did you see someone come by here? You say, well, yeah, I saw them walk that way. That is direct evidence. You saw it. Now imagine you're on that same beach and it's completely empty. You close your eyes for 5 minutes. Just relax. Before you closed your eyes, the beach was completely pristine. And when you open them up, now you see footprints. You can see the toes facing off to your right, the heels, and you see them go all the way around the rocks there. Somebody again runs up 5 minutes later and they say, hey, did someone come by here? And you go, well, I mean, I didn't see them, but they must have gone by in the last 5 minutes because you can see their footprints. They went that way. That is circumstantial evidence. You can infer from that that someone went by and where they went. The burden of proof. The state has the burden of proof, as we absolutely should. So let's talk a little bit about what it is and what it is not. You're told that the burden of proof is proof beyond a reasonable doubt. And the instruction tells you that that leaves you firmly convinced in the defendant's guilt. You're told there are very few things in this world that we know with absolute certainty. And in criminal cases, the law does not require proof that overcomes every doubt. If, based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find him or her guilty. So I want to start by saying what proof beyond a reasonable doubt is not. It is not proof beyond all doubt. It is not proof beyond all conceivable doubt. It's not proof beyond all possible doubt, and it's not no doubt. You're told that there are very few things in life we know with absolute certainty. So just because someone says, what if? That is not a reasonable doubt. What you're told is it's proof beyond a reasonable doubt. As we go through the evidence and apply it to the crimes, we will show you that there is no reasonable doubt as to this defendant's guilt. So let's start with the crime itself. Conspiracy to commit first-degree murder. There are 3 stages in this, or 3 things the state must prove. 1, that the defendant or her co-conspirator caused the death of another person. Well, we know that Alex Cox shot and killed Charles on July 11th of 2019. Alex called 911. Alex indicated he was the shooter. He was the only one home. It was his gun. His credit card or debit card was in there with the gun. And we know that Lori told the police that her brother killed Charles. So we know that he caused the death of, so that. 2, that they intended or knew that she or a co-conspirator would cause the death of another person. When we are looking at this case, we are looking at the defendant's words, actions, and motive. The words and actions of having her brother Alex come over on the 10th with a gun so that he would be there when Charles came over to pick up JJ. The actions that day of taking Charles's phone, ensuring that he could not leave, that he could not take his son to school. The defendant told the detectives how angry and screaming Charles was about the phone, but she didn't just give it to him, throw it at him, tell him to get out, whatever you might do. She held onto it and told the police that she walked away with it as he's trying to grab it. The defendant's actions and words show us that she is the only reason why Charles stayed in there and the only reason why Charles was shot. Then there's those 12 minutes. Defendant tried to pretend that this was a quick, angry scuffle. But Charles is there for 12 minutes. The defendant is there for 12 minutes.
Bye, Michelle.
Alex
is there for 12 minutes before she leaves. We look at her actions when she came back. She told the police her brother was hit in the head with a bat. She never asks how he is. She's not concerned about his injury. She's not concerned about her husband being dead on the floor of her house, her child now without a father. The lack of words that she said there and her demeanor show again that she was well aware of what was going on and part of this incident. We look at her words to Chad, that Charles changed his life insurance policy before we got rid of him. They show her intent to kill Charles. And again, we look at the motive, money and Chad. When did this happen? The first time Charles came back into town after he found out about the affair. Finally, the state has to prove that the defendant or the co-conspirator acted with premeditation. So I'm going to talk to you about premeditation. You have a jury instruction for it, and it tells you that the defendant or the co-conspirator intended to kill another human being or knew she or the co-conspirator would kill another human being, and that after forming that intent or knowledge reflected on the decision before killing. It is this reflection, regardless of the length of time in which it occurs, that distinguishes first-degree murder from second-degree murder. You're also told an act is not done with premeditation if it is the instant effect of a sudden quarrel or heat of passion. This is where you remember those 12 minutes and the calmness of her walking around with that phone and her demeanor. You're told the time needed for reflection is not necessarily prolonged, and the space of time between the intent or knowledge to kill and the act of killing may be very short. So I'm going to give you an example. It's a lot of legalese, and then we'll talk about what we really have here. So imagine again, you are driving your car, you do every day, and you're coming up to an intersection and you see the light turn yellow. And in that second you think, do I want to run it? Or do I want to slam on my brakes and hit it? Stop before I go into the intersection. You think about that, and then you decide, I'm going to slam on my brakes, and I'm going to stop. That is the time it takes to reflect. That is the time it takes for premeditation. But we have a lot more than this because we have planning, not just premeditation that morning. So when we talk about the premeditation that we see, it starts at least back in June, when we have Christina telling us about Alex Cox saying that he wanted to kill Charles, Lori having no reaction to that, and instead talking about drugging Charles. Did you hear Alex making some comments?
Yes.
And you told us that they made you uncomfortable. What were these comments?
He stated he wished that he could just kill Charles.
Okay. Was Lori around when he was saying this?
Yes, one of the times.
Okay. So he said it more than once.
Yes.
Can you describe for us part of his demeanor when he's saying this about wanting to just kill Charles?
It was jocular, just as I recall, he was standing up and just talking about it pretty loudly.
And you said one of the times that he said this, it was around Lori.
Yes.
Did she react in any way to hearing her brother say that he wished he could just kill her husband?
Not that I recall.
By July 9th, or when we start having this planning that we're talking about, we know that Lori Vallow is living in a house paid for by Charles Vallow. We know from even her statements to Detective Enclan that she doesn't like Charles, is what she says, but Charles won't file for a divorce.
We know from her words and text messages that she wants to be with Chad Daybell. But Charles is her cash cow. She hasn't worked. He pays rent, car, cell phones, her travel. And so, as far back as June 9th, we're already hearing that Alex and Lori would like to not just get rid of Charles, but kill him. But if you think that June 9th wasn't the beginning of this planning, this idea, this concept that Lori and her brother have of getting rid of Charles, this evil, dark, possessed person, then we know on the 9th that there is definitely a plan by this defendant. And we see that through those text messages with Melanie, with Summer, with Alex, where she speaks of the mission, where she talks about telling Melanie, you can't leave. You got to pretend to be sick and stay here and keep track of Brandon so he doesn't come help Charles. He can't be in the picture. We need to stay here to defend ourselves from an intervention. The 10th. Again, we have Melanie, who is talking to her and saying, that she wants to just go to this wedding. And what does Lori tell her? No, you have to stay here for the mission. The mission of stopping an intervention? No. As we continue through the 9th, we see Lori getting everyone lined up to help her. Alex, where he again is told that he will be like Nephi, just like her. Now Lori tells him it's an intervention. Everyone knows, Adam told you what's an intervention? It's talking to someone. It's common language. But that's not what the defendant wants to happen. She doesn't want Charles to divorce her and lose his money. She doesn't want this intervention to happen where she loses her temple recommend. What she wants is to be like Nephi and get rid of her husband.
Well, Nephi was a prophet in the Book of Mormon. It's the first chapter. He was a prophet, very humble and faithful servant of the Lord. Ironically enough, his brothers tried to kill him at one point. But he actually ended up going to Jerusalem to get these plates back, and he was run off, came back, and then went back again because the Lord asked him to. And when he did, the King Laban, who was actually a wicked king, was laying on the ground drunk in front of him, and Nephi was told to kill Laban.
Who was he told by?
The spirit, or God.
So God was using a Holy Spirit to tell him to kill Laban, and
Yes.
did he?
Yes, he did.
Was that something he anguished over?
Yes.
But ultimately, it was a justified killing.
Yes.
You heard from Detective Duncan that everyone he spoke with gave this same story. And again, the defendant questioned others about this story. But what we've heard is, from Detective Duncan and from Adam, that Nephi is this justified killing. When we think about her religious beliefs and what she's been telling people about not needing to repent, about telling people who is dark and evil, a zombie or a Z, that she is above the priesthood, it makes sense that she feels justified in determining who should live or die, just as she told her brother on the 9th. And we know that, in fact, we're talking about a justified killing because Alex brought a gun over. He didn't bring the Book of Mormon to talk to Charles about something. He didn't bring a friend to try to record Charles saying something. He brought a gun with him. And then he waited there for his sister's husband to come into the house so he could kill him. What we see is a very planned out, premeditated murder. But let's talk about some additional premeditation. Again, as we're looking at Summer, we see on the 10th that Lori is having her sister update her on where Adam and Zach are staying, so she knows they're not with Charles. They're not coming over. They're not going to be interfering with their justified killing. And there's that 12-minute time where the defendant desperately wanted to rewrite the timeline as they told the police that day. This just happened. It was very quick, but it wasn't. It was 12 minutes. Charles arrives at 7:37 and Lori leaves at 7:49. During this time is when that plan, that premeditated murder occurred. So let's talk about that as well. The evidence at the scene, the physical evidence, supports this premeditated murder. Alex fired 2 shots. One of them went through Charles' center mast, exited out his back, and went into the floorboard. The second one, Charles was on the floor, on his back, bleeding out, still able to move, and we know that because he had blood on his left hand, and he was executed as he lay there on the ground. In that time, when we talk about premeditation and reflection, as Adam had to move his hand down, reposition the gun, and discharge and pull the trigger one more time, that is premeditated first-degree murder, no matter what you believe before that. Again, when we talk about that physical evidence, we saw the fact that the location of that bullet defect in the ground matched right under Charles's left shoulder. And we heard from Dr. Baumgartner. Dr. Baumgartner told you that this was a classic shored wound. And no matter how many questions could be asked about him of maybe a bamboo shirt might stop a bullet in one location but not in another, or how many matrix-like hypotheticals where maybe Charles bounced back up and then on his way down, the bullet slowed down through him and waited till he hit the ground again before it exited. Dr. Baumgartner told you, no, those hypotheticals, those issues did not make sense. He's never seen a t-shirt stop a bullet in one location or at all. And we know Charles didn't bounce because we know he had no injuries to the back of his head. This also tells us a little bit about the shooting itself. When Charles was shot that first time through center mast, he did not fall straight back and land onto the ground, laying there on his back. If he had, he would have had bruising, abrasions on the back of his head when he hit the ground. He didn't have anything on the back of his head. Where did he have abrasions? On his knees. When he fell to the ground after being shot, Do we know how long it took him to roll over, to fall onto his back, before he was then shot a second time because he's still alive? You heard it could take up to 2 minutes for Charles to have died, and then he could have spoke and moved during that time period. What we do know is that he eventually ended up on his back. And while he was on his back is when he was shot the second time by Alex. This defendant and her brother in that house waiting and making sure that Charles was dead. Murdered, executed. Words, actions, motive, and physical evidence all tell you what happened that morning. So let's talk about conspiracy. And I know there are a lot of layers here, and I'm just building them up for you. You're told in your jury instructions that conspiracy requires proof. One, the defendant agreed with one or more persons that one of them or another would engage in certain conduct. So again, we look to Lori Vallow's words. What she had been talking about for months, Charles being possessed, being dark, wanting to kill him, the discussion on June 9th, poisoning him or drugging him previously. And then when we got to July 9th, it is all coming to a head. We will be like Nephi. Her actions, having Charles come to the house, instead of him staying there, she had him stay away. Why? Because if Charles stayed at the house, couldn't have Alex come over with a gun and be ready to shoot him, right? You got to have him come in. Her actions of inviting her brother over with a gun the night before so he would be there. She knew when he would show up. He texted her, "I'll be there at 7:30, pick up JJ." But most importantly, why did Charles stay in the house? Lori told the detective that Charles initially was like, "Oh, I'll just stay here for 20 minutes and then I'll take JJ to school." Well, she wasn't going to kill him in front of JJ. No, take JJ to Burger King. Get him out of the house. Go put him in the car. And he does that. But then she takes his phone. And she won't give it back. What she told the detective was, before this alleged Tylee bat, whatever thing you want to talk about there, that she had Charles's phone and was asking him about texting Adam. Of course, that's interesting because how would she have known that? But we know she had the phone actually for a while before she did that interview. She tells the detective numerous times that Charles is telling her to give him back his phone, and she will not. That she's walking around as he's trying to get the phone. She won't give it to him. Why? Because she needs Alex to come out. He brought that gun over for a reason. So she agreed with one or more persons, her brother, Alex, that she intended to promote or assist the commission of such conduct. Well, of course, we know both the promote, she is the one who on the 9th said, "We will be like Nephi. It's time to stop this whole thing. Charles trying to take my temple recommend, all this stuff that's going on. Time to kill him." And of course, she assists by ensuring that Charles stays in the house when she takes that phone. And of course, they knew that it would constitute first-degree murder. That's what Nephi did. Only unlike Nephi, where it was justified, here, ladies and gentlemen, this murder was not justified. Finally, think about the demeanor when you're thinking about, again,
words, actions, motive, and demeanor. When Lori comes back to the house, she is very, what did we hear that word many times? Nonchalant, calm, no questions about her brother, no questions about her husband, no questions about the house, just laughing about her neighbors. She is in absolute agreement with what has happened. She knows what's happened and she's calm and good with it because she doesn't need to repent. She is able to determine who should live and die, and she has done that. So when we talk of the scope of conspiracy, you're told that to prove a conspiracy, it is not necessary to show a formal meeting or express agreement. But we see that from the 9th, in that conversation that she and Alex had, where she tells him, you are going to have to stay near me for the next couple days, and we will be like Nephi. You're also told that a conspiracy may be inferred from circumstances showing a common criminal objective. So, just because you don't have someone who says, I heard them say, we shall conspire, you can infer that from the conduct of what happened on the 9th, the conduct of what happened on the 10th, and the conduct of what happened on the 11th. All infer to you a conspiracy of Alex coming over with his gun to shoot and kill Charles. As we again look at this in this conspiracy, again, we're looking at the same words and actions. March, Charles is no longer there. There's just an evil spirit in his body. June, Charles is still possessed, and now Alex is saying he wants to kill him. Lori is fine with this, and she says she's drugging him, or had been drugging him. And then 2 weeks before, all of a sudden, Charles knows Lori's been having this affair. Lori's words, actions, motive, and the physical evidence. Conspiracy again, we see that Lori and Alex know exactly when Charles is showing up. Alex doesn't go to the door, according to Lori, and confront Charles or tell him we'll send JJ out and you can leave with him. The world is so difficult. How hard would that be? Bring JJ right to the door and let him leave with his dad. No, you aren't going to shoot him outside. You want to make it look like self-defense inside. As you go through this and we think about what's going on, the defendant doesn't even care. She wants her husband killed so bad that she's willing to let her brother bring over a loaded gun in an unlocked gun case in a house with a 7-year-old autistic child. That's fine. When the defendant was questioning Detective Enclen, she was talking about how hot it was outside. JJ's out in the car. But she has no problem with an unlocked gun in the house with the kid, and she's worried about her child out in the car? She's not. We know that because she's the reason Charles doesn't go back out into the car and leave. She keeps him there in the house. She is why JJ's out in the car alone. She has to keep him there until Alex comes out and can shoot and kill him. When we talk about that premeditation, obviously we're talking about that message. We know from the 9th on, they are premeditated, they are conspiring, and it's all heading to July 11th. We look at the timing of this, and this is actions and non-actions. Charles is in the house for 12 minutes. After those 12 minutes, they wait 47 more minutes before they call 911. Why? To stage the scene. No CPR is performed.
They wait for Charles to be dead, and then they talk during this time period. They talk. They could call 911, but nope, they're going to just talk. So again, you're looking at their actions, what happened and didn't happen, and the motives. There's the gun that was used to kill Charles. We're going to go through a couple of these exhibits, some of what Lori said, and it's exhibits 192 and 197, where she again says that Charles came over and said he was just going to hang out at the house for like 20 minutes, take JJ to school. She, of course, tells him to go. And when JJ is out in the car, she has Charles's phone, and she won't give it back. And no matter how much she says that Charles is screaming at her to give the phone back, she won't. And all of this conversation about Charles demanding the phone back is prior to her statement to Detective Enclin that Tylee comes out with this fact. This is all her doing. This is her as an accomplice assisting and promoting this murder. Lori is setting up Charles so Alex can shoot him.
And with JJ?
So he put it in the car,
Okay.
in the driveway, and then he came back in, right? So I kissed JJ goodbye. He came back in, and his phone was on the counter, and I had his phone. And he was like, give me my phone. And I was like, why don't you show me your text that you've been texting, blah, 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 you know, whatever. Because he's like acting really weird, like he's plotting something against me. Like, I'm like, why are you even here? Like, what did you come here for, you know? He's been talking to my other brother, and my brother came into town at the same time last night. And I haven't talked to my brother in a while, my other brother, and I was like, and so he was texting him on the phone when he first got to my house, and I'm like, why are you texting Adam? Like, do you even talk to him? Like, my other brother.
So when you listen to these clips and the interview of Lori Vallow, you have to put into context, this is 9:52 in the morning when this part of this interview is occurring. And she's telling the detective that she confronts Charles about texting her brother Adam. Now, she's had the 47 minutes she's been driving around, and then that time at the house when she's waiting outside to learn all of those texts and what's been going on between her brother and Adam and Charles. And so she is now mixing this into her interview. And so when you're listening to her interview, we know she's trying to work out this, what happened, how did this go? You can watch her demeanor as well. And as you're going through this, see how she's just telling a story here, like what happened, almost chuckling about it.
Okay. So this morning he comes back in and...
He comes back in, I wouldn't give him his phone, he was screaming at me to give him his phone. He was very worried about whatever was on his text that he did not want me to see. And so I was just holding it there, and he was screaming at me. And I was kind of walking towards around the house with it, so he couldn't get it. He's like reaching for it and stuff like that.
So again, JJ's in the car, Tylee's not out, Alex isn't out, and she is making sure that he doesn't leave. She's walking around the house, holding his phone, refusing to give it to him, making sure her autistic child is sitting out in the car even longer so that she can ensure that exactly what they've been planning happens, that Alex has time to come out with the gun that he brought over and shoot and kill Charles. This defendant is the only reason why Charles didn't leave with JJ. This defendant is the one who provoked Charles by taking his phone and refusing to get it back. This defendant is the one who ensured that Charles was inside without JJ so Alex could shoot him. And this defendant is the person who set up Charles so that her brother Alex could shoot him. Let's talk about staging the scene. We know obviously from the first responders that When they arrived, no CPR was given. You heard from Officer Wierzbecki that when he felt Charles's neck, he thought he was dead already, but they still let the first responders in because they've been told CPR had been given. And what do we know? That they arrived within a few minutes. No one had ever tried to save Charles. No blood had been pushed out of him from CPR, whether strong or light. He had been dead for quite a while. His skin was mottled when they started cutting open his shirt and looking to the back, and lividity, the blood pooling, was occurring already. So they kind of knew something was off with that timeline. So what about the scene itself? The bat. It is placed to the right of Charles to look like he was using it. He got shot and it went flying behind him. Well, obviously we've heard from Kay, Charles's sister, that he was left-handed. We know from the blood evidence on his hand he was left-handed. There's no damage to that mirror. There's no damage to the drywall. There's no damage anywhere, like this bat is being swung around in this horrific fight that's going on of grappling. The injury to Alex Cox's head. You heard it was a small 1-inch cut, that he was using a paper towel to pat, and at times, as you watch that Exhibit 1, rubbing it, making sure it stays bleeding. There is no blood at the scene from this giant grappling thing going on that Lori Vallow wanted them to believe. His head is bleeding and they're grappling around and he's being beat with this bat, and yet not one drop of blood on the floor. Not one drop of blood going down the hallway when he put that gun away. Not one drop of blood on the gun itself. And then the shoes, left by the door to look like Lori Vallow had run out in fear after this horrific incident that they planned. But what we know from the Walgreens video is that she did enter the store with shoes, something on her feet. So we're going to go through. We know Charles, again, left-handed.
Field with your brother. Yeah. What position did your brother play?
He was a pitcher. He was very, very good. He was a left-handed pitcher, and they're very hard to hit against.
Okay. Did he bat right or left-handed?
He was left-handed.
Did he do everything left-handed?
Yes.
Left-handed? So we know that Charles batted left-handed, not right-handed. And what we know is Lori Vallow had a story about how Charles was using that bat. And it becomes very important as well when we're talking about the staging of the scene. This is Exhibit 193.
Yeah, she was outside. And
then what happened?
Then they got up from that, and my brother had like stepped back, I guess, and then Charles was coming with me to that and yelling at me to give him his phone still, because I had it in my hand. It was all really quickly. And then when I went around kind of in the circle, then my brother was there.
When you said when you were going around and he was coming at you with the bat, how was he holding the bat?
Just like that, like backwards, almost in one arm.
Like he was swinging, but like swinging it backwards? He would have done like
he would have swung it backwards at me, not frontward.
Okay.
So Lori Vallow tells Detective Enclan that Charles is swinging the bat backwards. Now, if the bat was like this when he was shot, his arm would have been shot. Covers his center mass. So we know he wasn't here. So if he's out here, where would the bat go? Down, out, somewhere that way to his left. It would not end up thrown up above him. And if it wasn't there again, Charles would have been shot through the arm. Obviously, Alex forgot that Charles was left-handed. So when he placed that, like he was coming at him with a bat, their stories didn't quite match up with the evidence. So if we rely on Lori's story of how Charles was holding the bat, then there's zero way that that bat would end up where it ended up. And again, we know he's left-handed from not only Kay, but his own admissions of that blood on his hand. So we see the scene is staged, this bat that is so necessary to try to ensure this justified killing is legally justified and not just spiritually justified. When we talk about the scene as well, and you're looking at where Charles was, at least when that second shot went through him, you can see in the photograph to the right, the shot to Charles's chest, right between his nipples, and the shot to Charles's abdomen down lower. We know that that first shot through his chest, that Charles would have been facing a little more towards the open area there where we see the hallway and the kitchen. We know that because there was the bullet trajectory Detective Cruz told you about that entered that far east wall. We know there was stippling, and so the defendant would have been, well, her brother would have been within 2 to 4 feet of the muzzle of that gun within Charles, 2 to 4 feet. We know from the lack of that injury to the back of his head that he didn't fall straight back. We know from the blood on his hand that he was still alive after he was shot. And we know the lack of stippling for that shot to his abdomen and that trajectory, and even the defendant's own statements that she saw her brother at Charles's feet, that he would have stood there at Charles's feet when he fired that second shot as he was laying on the floor. You have the bat, Exhibit 249. You can look at the edge of it. You see the photograph of the edge of it. There is no blood and no damage to this bat. Regardless of how many times the defendant was hoping that blood was invisible, we have all cut ourselves and seen that blood is red. And there was no blood on this bat. There is no blood on this bat. There is no damage to this bat. So you have a semi-professional baseball player who has a bat in his hand, and he sees someone with a gun and doesn't beat him with it, take his head off with it, knock him unconscious with it. Instead, all we see on this bat is 0 damage and 2 partial prints. No prints of a body or smushed skin on it, someone that's sweating from a fight that's left a large arm print on it or anything else. Nope, just 2 partial little prints on it. When you think about what is there and what isn't there, does the evidence of this bat fit in at all? It doesn't. We look at Charles's watch. No damage to it, no scratches to it, no dings to it as he's grappling on the floor like Lori wants you to believe. We know that at some point, Charles is standing and shot, and we know that final shot, he's on the ground. We know he fell to his knees at some point. And when you look at that physical evidence and the lack of damage or anything on that bat, again, what makes sense is that Charles fell to his knees after that first shot. We know that there is 12 minutes where the defendant and her brother are still together there, so that Alex can get this 1-inch cut to the back of his head that's barely bleeding, that he uses a paper towel to dab at and rub. The shoes that the defendant ran out of on her way out. You have the exhibit. You can see black straps across her toes as she enters and exits the Walgreens. And then you see that she's wearing the flip-flops when she comes back to the scene. What do we know? That the police did not search Charles's rental car. Credibility. You are given a credibility instruction and you use it for everyone, including the defendant. You're told that you really evaluate people the same way. You're looking for any inconsistencies in their stories, any reasons why they may have a motive or bias to lie, any prejudice they may have, and then you look at everything in light of reason, common sense, and experience. When you think of the testimony of the people who come here and talk to you, Christina Atwood, Serena Sharp, Nancy Jo Hancock, Adam Cox, Dr. Bumgardner, the detectives, Robin Smith Scott, Mark Zari, what benefit do these people have in being untruthful to you? They have body cameras, they have prior documents, and they have memories of what this defendant said. But the credibility of Lori Vallow is something you do need to consider. And you start with her demeanor that day, where she wasn't worried about anything when she arrived. Her brother has allegedly been hit in the head with a bat by her husband, who plays semi-pro ball. She doesn't even worry about him. She knows he's not hurt. He's fine. And why does she know that? Because that was staged. When she's there and we see her on body cam arriving, she's just nonchalant and calm. And I know the defendant wanted to make sure that it was clear that everyone else was calm, but no one else had just allegedly seen their husband get shot and killed by their brother. When you were looking at the reasonableness of her testimony, you have to consider it in the light of reason, common sense, and experience. And the way that she was acting and reacting that day, as well as her own statements, do not fit the evidence, do not fit the physical evidence, and you will see her credibility throughout this whole case has been questionable. Her credibility with Social Security. What did we learn? That on July 11th, she tells Detective Enclan that she and Charles are separated. Exhibit 187. We are not living together. Charles rented her house. We're separated. But on August 12th, when she needs to make sure she gets some money, she tells Social Security, when they ask, are you living together at the time of death? Yes. You also learned that she was not truthful with Social Security when she got remarried. She did not tell them about that either. So you know she's been untruthful to Social Security twice. Why is that relevant? Because you're judging the credibility of Lori Vallow throughout all of this. Life insurance. We know that she said Charles was accidentally shot. We know that was not true. She wanted to make things seem like she had nothing to do with the murder. But we know that Alex Cox intentionally shot Charles. Whether or not she wants to claim it's self-defense or not, there was nothing accidental about shooting him twice. Then that second call to Banner Life Insurance, where she tells Robin Smith Scott a few different things to garner sympathy, and she asked her if she could do anything about the change in beneficiary.
I really can't give too much information, but I can tell you that the beneficiary was changed in March of this year. Okay. Okay, I'm trying to figure out what he was doing since we have 5 kids and we've been married for 15 years. Oh, I'm sorry.
So Lori tells this woman, we have 5 kids, which if you want to count them all and admit that 3 of them are adults, then okay. Really, they have 1 kid in common. Tylee, you learned, was actually getting Social Security survivor benefits from her dad's death starting in 2018. Lori's son, Colby, isn't living with them. Charles' son's never lived with them. Why does she say these things? She can't help it. She just wants to just make herself seem better than she is. What about the credibility of her interview, even during the police interview? We talked about a few things, but one of the things she told the detective.
And I didn't file anything or whatever. And then he filed something against me and said, I'm only going to get supervised visits because I'm crazy and blah, 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 you know, the story. And so I just didn't talk to him for like 30 days. and let him take care of him and let him see what I've enjoyed.
So again, she can't even be honest and say 2 months. She's got to be like 30 days. I was kind enough to just leave my husband with my son for 30 days. What we know is that Lori Vallow was gone a total of 78 days, 58 while she's flying to Hawaii, going to Idaho and back with Chad. And who's taking care of JJ? Charles. And Kay is coming here regularly to help take care of JJ, to help run the business. And then eventually on March 28th, that's when Charles finally decides he hasn't been able to find Lori. He doesn't know where she is. He's going to move to Houston to be closer so his sister can help him more easily. And this is when Lori finally shows back up. So again, even the simplest thing of just trying to be honest about how long she's been gone, she has to minimize it and make herself seem better.
With your cross.
The shoes. Oops. This will play. When she was questioning Detective N-Clan, she was asking her if it was hot in July and if she would need shoes to go take her son to school. But of course, what we know is that we saw her with those shoes on as she went into Walgreens. So again, it's continued trying to garner sympathy and just being untruthful about whatever she feels like being untruthful about. And then we look at the credibility in that timeline, that body cam.
You live here though, now that you're not in Santana, this is your home?
Right,
Gotcha.
right.
Okay.
We just moved in here.
Gotcha. How long have you guys lived here?
I'm sorry?
How long have you lived here?
Like 3 weeks.
Oh, geez. Yeah, okay.
That's why the neighbors don't know us.
Gotcha.
Like, hi neighbor, sorry.
How you working?
So here she is, 47 minutes after leaving the house, laughing and smiling with the detective about the fact that her husband is dead inside the house. Her brother is sitting on the curb, allegedly with this very serious injury from a baseball bat. When you look at that credibility of the defendant, you have to look at everything together and what fits, again, with the physical evidence and what doesn't. Finally, let's talk about the justification defenses. What we know is that Lori Vallow thought she was like Nephi, that she was justified in killing Charles, that her brother, who was supposed to be like her, was also justified in killing Charles. But Lori Vallow is not justified under Arizona law, nor is Alex. So let's go through the different justification defenses. First thing that you have to consider for every one of these, self-defense, defense of a third person, or crime prevention, is the non-justification for use of deadly physical force. You're told if a person is not justified in using or threatening physical force or deadly physical force against another in response to verbal provocation alone. So Charles yelling and screaming at her to give his phone back does not justify you shooting him. Or a person is not justified in using or threatening deadly physical force if the defendant or co-conspirator provoked the other's use or attempted use of unlawful physical force. So we know here Lori provoked Charles by taking his phone and refusing to give it back. So again, when we look at every one of these defenses, you'll see not only do they not apply, but none of them is the defendant entitled to. This is not self-defense. In self-defense, you're told that a reasonable person, can use deadly physical force if they believed that deadly physical force was immediately necessary to protect against another's use or apparent attempted or threatened use of unlawful deadly physical force, and the person used or threatened no more deadly physical force than would have appeared necessary to a reasonable person in this situation. We know that Lori Vallow used Charles's phone to get him to come back inside, and she used his phone to keep him inside and give her brother time to come out and shoot and kill Charles. We know from the physical scene itself that Charles did not use a bat. We know from the physical evidence of Alex's 1-inch cut to his head and the lack of blood or concussion, the lack of damage to the mirrors, the walls, the location of the bat in relation to Charles, they all tell us that Charles did not use a bat. We know that Charles was a semi-professional baseball player. This would not have ended that way if he had had a bat. But even if you somehow think that he did have a bat and he was swinging it at Alex, the defendant, whoever, he still was not justified in shooting him when he was on the ground. It has to be immediately necessary to protect against another's use. When Charles is on the ground and he is shot that second time, there is no threat to anyone. And so that is not self-defense.
Counsel, I need to give my court reporter a break unless you think you'll be done in the next 5 minutes. Okay, go ahead.
When we look at the physical evidence, again, we know that Charles was on the ground, shot, and so this is not self-defense. And we know from the physical evidence at the scene, the projectile into the floorboard, this is not self-defense. Third party. You're told that a person is justified in using or threatening deadly physical force in defense of a third person, I presume here Lori Vallow. If a reasonable person in this situation would have believed that deadly physical force was necessary to protect against another's use, again, of unlawful deadly physical force against a third person, and they used only what was necessary for a reasonable person under the situation. What do we know? Lori Vallow told Detective Enclan that she wasn't even in the room when she heard the shot, that she had gone around into the kitchen. Who's he protecting at that point? What third person that's no longer there is he protecting? You can't protect against a future, what might happen, or what already occurred. It has to be now. And Lori Vallow herself put herself outside the room when her brother shot Charles. So there's no third-party defense. But again, the same thing applies. Even if you thought so, that second shot removes any possibility of being justified. Crime prevention. This is the exact same thing, only in a slightly different stated way. But like self-defense, it allows a person to use deadly physical force against another to the extent a reasonable person would have believed that deadly physical force was immediately necessary to prevent Charles from committing aggravated assault against Lori Vallow. We know she's not in the room. Even if he had that bat and had been coming at her and then she left the room, that crime is over. And again, even if you believe he had the bat, you cannot shoot him while he's on the ground. That is not what crime prevention permits you to execute a person. Finally, there's mere presence. You're told that guilt cannot be established by a defendant's mere presence at the crime scene, mere association with another person at the crime scene, or mere knowledge that a crime is being committed. Lori Vallow wasn't just present at this crime scene. She brought her brother to the crime scene. She ensured that he brought a gun with him. She ensured that JJ was outside, and she ensured that Charles stayed inside. She was not merely present. She was a person who was actively participating in this crime. Ladies and gentlemen, we have talked about the evidence in this case. Evidence that was presented to you through witnesses who took the stand and exhibits that were admitted for you to review. Remember the evidence of Lori Vallow's motive. Charles's life insurance, Chad Daybell. Remember Lori Vallow's own words of wanting to get rid of Charles, of drugging him, her acceptance of her brother's statements that he wanted to kill Charles, how she used Melanie and Summer to plan her mission and ensure that Charles didn't have help from Brandon or Zach or Adam. Her words to Alex about it all coming to a head, that he had to stay near her and they would be like Nephi, justified in killing Charles. And finally, her words to Chad Daybell on July 18th, confessing to the killing when she said Charles had changed the life insurance before we got rid of him. Look at her actions and demeanor, having her brother come over on the 10th to her house with a loaded .45 caliber handgun, creating the one and only reason why Charles stayed inside the house, why he didn't just take JJ to school. The 12 minutes that Charles is at the house before Lori leaves in the car, the 47 minutes after that before they call 911, her demeanor when she comes back, not caring that anyone has been hurt, her demeanor on the body-worn camera, during her interview, what you heard about during the drive. Think about her credibility, how she cried for you in her opening statement. You certainly didn't see her cry on that body camera footage. You didn't hear about her crying as she was being driven to the Family Advocacy Center, and you did not see her cry in her interview. Finally, think about the physical evidence that proves that Lori and Alex staged this scene, that Charles was never in possession of that bat when he was shot by Alex, or either of the shots, that instead he was executed that day for this defendant's benefit. The physical evidence disproves beyond a reasonable doubt that Lori Vallow and Alex Cox were justified under the law in killing Charles. The jury instructions tell you to use reason, common sense, and experience. Charles Vallow is dead today because this defendant and her brother Alex Cox conspired to kill him. They planned it out, and they had their weapons, and they orchestrated a way to ensure that Charles was back in the house where he was shot and killed for money and Chad Daybell. The evidence proves to you that Lori Vallow Daybell is guilty of conspiracy to commit first-degree murder, and the state asks you to hold her accountable and find her guilty. Thank you.
All right, we're going to take our 15-minute afternoon recess. I'll remind the jurors to remember the admonition will resume in 15 minutes.
All right,
On to Lori's closing. How y'all think that's going to go? How do you think that is going to go? How do you think that's going to go? Hold on. Let me make a poll real quick. Let me do a poll in the chat real quick. Hold on. Hold on, I'm working on this poll real quick. Wait a minute. Why is this being stupid? I hate whenever I mess up like that. Hold on a minute. Hmm. Okay. Okay. There we go. There's a little chat. Or a little poll, I mean. Should be interesting, right? It'll be the evidence will show 1,000 times. Oh my God. Ooh, Sherry says I think she'll preach. Sure, yeah, Cherie's earbuds are fully charged. Jeez Louise. Mhm. Mm. All right. Looks like the vote count is going up. We got 5 votes so far. Cynthia says, isn't it capped at 1 hour? I'm not sure. Did I give Margaret her one poll? Yeah, she's had a few polls. That woman and her polls. I voted 5 times. See, Margaret, that's why your your poll privileges are revoked. Patricia says she's going to yammer on. Oh my God, you guys, I am so sleepy. And here also, I don't know what we'll do because they're going to go and deliberate. And probably what's going to have to happen because I don't think that I'll be able to stream much past her closing, actually, because Kiddo, we got to do dinner and get Kiddo in the bed. So, yeah. This is why I don't like the West Coast times streams. You know what I mean? Hi, baby. Whoa, Nelly, what are you doing? Silly goose. You're a silly goose. Oh, yeah. Did you get cakey? Okay. You love cakey. Her little stuffed animals. Mm. Morgana says, Margaret, get off the pole. So, like I was saying, as far as what do you call it? Verdict watch. Yeah. That's not gonna happen here tonight. What, babe? Huh? She's telling on her daddy because her daddy's asleep in the chair in my recliner. Okay, I'll be quiet. She's giving me the shush face. Go, go, go. She's so funny. She's like, Cynthia says I'm on PST time until time changes. So, yeah. So I'm excited about Karen Reed's trial being, in my time zone. I wouldn't normally mind, but not on school nights because I'm sleepy. Hold on, I'm gonna have to run her out. Sweet child of mine, what are you doing? You'll have to go in there and sit with Daddy for a little bit. Mommy will be off the computer in a little bit. Okay? Go tell Daddy it's time to cook dinner. It's dinner time. But yeah, I will definitely be watching the verdict from my phone though, like watching, but we won't be able to do the verdict watch live streamed. Dag nabbit. Oh, hold on. I'm gonna have to hold on a minute. I'm gonna have to run her off. Kylie says, I'm sorry, but if this was any other case, the prosecution would have absolutely lost me, arguing that the second shot couldn't be justified. Well, I get that. I do see what you're saying. I mean, the who was the snowplow one? You know what I'm saying? He was saying that was in self-defense and he used a firearm, but he shot like multiple times. You know what I mean? And he was on the ground for part of it too. So I don't know. But I agree with this with any other case, maybe. But definitely not Lori. Definitely not Lori. Kylie, what do you think? I want to know what you think about how Alex Cox died, her brother. Do you think that it was natural causes or do you think, hold on just a second. I have to remind husband that I'm still on the computer. I'll be right back. Okay, I'm back. So, she was in there putting her little pink gum boots on. I call them gum boots, but they're pink rain boots. She's not going outside, but you know. It was just presented, Kylie said it was just presented in such a black and white way over and over. And there's plenty of times it takes more than one. It was just a bit sanctimonious. Uh, I know, right, Cynthia? She's a doll baby. I haven't heard much about it, but I wouldn't put poisoning past Lori for anything. Mm. Sherry says I wouldn't either. Latanya says I think Alex went and got some pills from Mexico to off himself after that last blessing Chad gave him. That's what I think too. And she lies so smoothly that she would absolutely explain it away believably. Well, and for real. I mean, she had these folks snowballed for a minute. You know what I mean? The cops, I mean, in this situation, like during the interview, the cops are like, I'm so sorry. I mean, completely for a minute. But Latanya, I do agree with that. I think that that's what happened. And I don't know if he was under the belief, if they manipulated him to believe that his mission was done and now it was his time to go through with his, what do you call, like, martyrdom, you know what I'm saying? Or if he just came to the conclusion that he couldn't live with himself and he knew they were going to come get him and take him away and throw away the key. And he was like, well, I'll just, do it myself. Collect his reward, Sherry, right? Collect his reward.
How long does it last?
Manipulation left, right, and center. Did you watch Chad Daybell's trial, Kylie? We streamed it here. If you haven't seen it, you really should go watch it. You're going to learn so much. It's the biggest rabbit hole on the planet. Right, Miss King. Mm-hmm. Are your guys' allergies like having massive fits this last week or so? Oh my God. My allergies are starting to kick up. Her and they're hacking her head off. My kiddo, God love her heart. But I've been trying to get this little tickle cough. And my nose is like dried up one minute and running the next. Oh. I've been taking
All right, please be seated. The jury is present.
here we go. But hold on real quick. Out of control. Spin says I got headaches with my allergies. So I was taking Flonase during the day and Zyrtec at night. And then I got to where I was just taking the Zyrtec at night. Now I'm going to have to start taking the Flonase during the day again because, yeah. Kylie said, no, this is the first one, even adjacent. I've caught pieces. I only knew about the kids and some of the key points from Kathy's recaps. Super late to this party. Oh my God. Honey, honey, honey. You really should go back and watch it. You'll get so much more. You'll get so much more. I don't know. Now, Lori's trial, when they did Lori's first trial, they did not live stream it, but we did get audio. Like every day we would get a new audio file and you could hear it, right? You could hear the audio from the entire trial, but you couldn't see anything. Now, whenever it came to her sentencing, or what wasn't her sentencing, it was her, I think the verdict, maybe. When they went to announce the verdict, they did live stream that. They either live streamed the verdict being read or her sentencing. I don't remember which. And maybe it was both done at the same time. I can't remember. But Cherie's allergies are driving her insane too. Only 1% of my brain is saying just give Lori a benefit of the doubt, and the other half of my brain is saying, oh no, yeah, there's no benefit. Like I have a 0.00 I'm in the negative with doubt for Lori. I mean, at this point, I'm willing to put anybody in the vicinity that died that she ain't even laid eyes on. She probably had something to do with it at this point, allegedly. That's a joke. I'm not being serious. But it's like people just fall dead all the way around her. She's like the Grim Reaper or something. I don't even know. Okay, here we go.
The defendant can proceed with her closing argument.
Yes. Here we go. Yes, she is. Hey, Tracy.
Of the jury, the state of Arizona has the 100% burden of proving that I committed a crime, a grievous crime, conspiracy to commit premeditated murder of my husband, Charles Vallow. The state has the burden of proving to you that this event was not self-defense. In your jury instruction under the instruction, use of force and crime prevention, the last line reads, if the state fails to carry this burden, then you must find the defendant not guilty. In the law, under your jury instruction titled Justification for Defense of a Third Party, the last line reads, if the state fails to carry this burden, you must find the defendant not guilty. Under your jury instruction titled Justification for Self-Defense, the last line reads, if the state fails to carry this burden, you must find the defendant not guilty. In your jury instruction, under presumption of innocence, it states, the law does not require the defendant to prove innocence. Every defendant is presumed by law to be innocent. Under the burden of proof, it explains that the state's burden is this. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. If, on the other hand, you think there's a real possibility that he is not guilty, you must give him the benefit of the doubt and find him not guilty. In Arizona, self-defense is defined as not being a crime. So let's look at what we've learned in this trial. We learned that a shooting occurred and that 911 was called, that law enforcement was notified. We learned that fire, EMS, and Chandler police arrived at the scene. We learned that my brother, Alex Cox, came out of the house with his hands up as directed by 911 and was questioned by the police in the driveway. We learned that I came up with my daughter Tylee, and we were told to wait by the car until police would speak with us. We learned from Detective Inklin on the stand that we asked for Tylee's medication from the house for her panic attacks, but it was not given to her. We learned that eventually my brother Alex was taken in a police car to the Chandler Police Department uncuffed. We learned in this trial that my daughter Tylee and I were also taken to Chandler Police Department in a police van. We heard from Detective Inklin's testimony that her goal was to make small talk with us. And
The jury will determine what the testimony did or did not show. Go ahead.
that her goal was to make the small talk with us and all the way to the station so she could speak with us separately before we would talk about what actually happened. We learned that all three of us were separated and taken to 3 interview rooms where we each told police of the events of the day, each from our own perspectives, and answered all questions asked of us. We saw snippets of that interview in the trial here. The state did not show you the entire interview. Most of my police interview is admitted, though, into evidence in this exhibit. It's number 286. And I would encourage you to watch that entire interview when you start your deliberations. It is important. It is important for you to determine for yourselves my demeanor and not listen to anyone else. You can see it with your own eyes and hear it with your own ears. We heard from several witnesses that because
I'm sorry to cut her off right in the middle, but Lori, everybody watched it once and you were nonchalant. That's it. That was your demeanor. You were nonchalant.
this event was almost 6 years ago, that their memories of the events and statements were probably better back then. Well, my police interview happened that very morning, and I told the police the events from my perspective at that time. It is admitted into evidence and will answer many of your questions. You did not see Tylee's interview, but we did learn from Detective Inklin that she did an interview that morning as well. You did not see Alex's interview, but we learned that Alex was interviewed that morning by Detective Moffett, the original case agent, whom we did not hear from in this trial. The state chose not to show you those interviews.
Object, Your Honor.
Or let you listen to the 911 call.
Right.
The jury shall disregard that last statement. Okay, the jury can only consider what was admitted into evidence.
We learned in this trial from Officer Kautheim's testimony that Alex was injured on the back of his head with a bump, and according to his testimony, a 1-inch.
I'm sorry, I got to rewind it and hear what she said. I just heard something about the 911 call, and then the prosecution objected. I need to hear
From my
that again.
perspective at that time. It is admitted into evidence and will answer many of your questions. You did not see Tylee's interview, but we did learn from Detective Inklin that she did an interview that morning as well. You did not see Alex's interview, but we learned that Alex was interviewed that morning by Detective Moffett, the original case agent, whom we did not hear from in this trial. The state chose not to show you those interviews.
Object, Your Honor.
Or let you listen to the 911 call.
Right.
The jury shall disregard that last statement. Okay, the jury can only consider what was admitted into evidence.
Wow.
We learned in this trial from Officer Kautheim's testimony that Alex was injured on the back of his head with a bump, and according to his testimony, a 1-inch laceration. We did not see those pictures documenting that injury as well. We learned in this trial that we did not know, the 3 of us, that our interviews were being recorded. We learned that Alex's phone was taken by police and put into an evidence bag, according to Detective Duncan, and that no digital copy of Alex's phone was taken by the Chandler Police Department, even though this is their normal protocol. We learned that Alex's phone was returned to him that same day with no further inquiries. We learned that after my interview and Tylee's interview that we were introduced to a victim's advocate and that gave us further instructions in another room where Tylee and I were reunited. We learned that soon after that, all three of us, Alex, Tylee, and myself, were taken in another van and dropped off back at our house. We learned that we were instructed at that time that we could not enter the house yet, that we were directed by law enforcement to take the rental car, since all three of our cars were inside the police tape.
Yes.
We were directed to return later in the afternoon when the scene was cleaned up.
It's something else, though, not
We
an
learned in
actual
this
ring.
trial that we did as directed and left the house in the rental car close to 12 p.m.
It's like plastic or tape or something.
We learned that we did not return to the house until contacted by Detective Inkland to return to the house so that Alex could walk the detectives through what they call a walkthrough. We learned that many detectives were present during that walkthrough with Alex. We learned that Detective Duncan was there, Detective Coons was there, Detective Moffett was there, Detective Werther was there, and an officer with a body cam was there. And yet, we were told by Detective Duncan, the case agent on this case on the stand, that because of some problem, the walkthrough is not recorded. Detective Duncan also informed us that he does not know if any of the people present wrote a report about it. We can infer from Detective Duncan's testimony and the fact that we don't have in evidence any body cam footage of the walkthrough and no reports talking about it, that there are none, even though this would be crucial evidence for you, the jury, to have.
Sustained, the jury should disregard that comment. Again, the jury can only consider evidence that was admitted into testimony. I'm sorry, testimony that was admitted into evidence or exhibits that were admitted into evidence.
The state of Arizona has the obligation to show you evidence to prove that this event was not self-defense, as stated by the only 3 witnesses. So why not show the jury all the evidence that they gathered?
Again, sustained, the jury can only consider the evidence and testimony that was admitted into evidence.
We learned in this trial that Alex fully cooperated with law enforcement. We learned that my daughter Tylee fully cooperated with law enforcement. We learned that I fully cooperated with law enforcement. We learned that law enforcement treated all of us that day kindly and courteously on July 11th, 2019. That law enforcement treated us that day like this was self-defense. We were not given instructions to stay in town. We were not given instructions that we were under investigation of any kind. On July 11th, 2019, we were interviewed by Chandler Police and released with no further instructions. We learned that Chandler Police put out a press release that day on July 11th.
I'll sustain that objection to the extent the jury is to determine what the facts did or did not establish.
Under Arizona law, I had the right to self-defense. Tylee had the right to self-defense. Alex had the right to self-defense. This event was not planned or expected. It was shocking. We learned in this trial that Chandler Police Department neglected to do a thorough investigation. We learned that they did not swab Alex's hands for gunpowder residue. We learned that they did not swab my hands for gunpowder residue. We learned that they did not swab Tylee's hands for gunpowder residue. We learned that they did not luminol the gun. We learned that they did not luminol the bat. They did not test the DNA on the bat that they collected. They did not test the floorboard. They did not test the projectile. They did not test my husband's shirt. They did not search the rental car. They did not search any of our 3 cars that were there at the scene. They did not test the gun until over 5 years later. The Chandler Police Department did treat this event just like it was self-defense and a tragic family event. We learned in this trial that Charles and I were obviously having marital problems. regardless of what was happening in our marriage at the time, on July 11th, this was self-defense. When Tylee came out with the bat to protect me, her mother, Charles did not have to take the bat from Tylee and start swinging. At 62 years old, Charles had a choice that day and could have put the bat down. A 2-minute period changed our lives forever. How are you supposed to choose between 3 people you love? Your husband, your daughter, your brother?
Testifying at this point? Not facts.
All right, hold on. All right, I'll caution the defendant not to testify about things that were not entered into evidence.
How can you decide for another person if they feel threatened? Why does the state want to blame to someone?
It's a reasonable person standard, not the standard of the person.
I'm sure you'll point that out in rebuttal. I'll allow the argument as that inference. Go ahead.
Why does the state want to blame someone for this tragic event? What evidence did the state show you in this trial that I wanted harm to come to my husband? We learned in this trial that I was praying for my husband. We learned in this trial that even though my husband and I were having marital issues, that we were both trying to do the best things for our son with special needs, JJ. We learned in this trial that I was shocked that Charles had changed his life insurance policy, but I was not angry as the state alleges. In the phone call we heard from the insurance company, we heard that I was disappointed for our children, our grown children, as well as our children still at home, but I was not angry. My husband Charles was providing for our children still at home. I had no motive to change that. We heard a lot in this trial about the Book of Mormon prophet named Nephi. This is the state's evidence to murder over self-defense, and it is utterly ridiculous. We heard from Detective Duncan, who admitted on the stand that he had no idea what I meant in the text message when I said, "We will be like Nephi." In Mormon culture, Nephi signifies strong faith, perseverance, and courage.
Evidence not in the
Right.
defendant testifying.
That's sustained.
The state's attempt to misconstrue the positive text message about a wonderful religious figure, Nephi, and try to turn it into an order to kill someone is absurd. This is an attempt by the state to try to retrofit a crime that doesn't exist. This event was not a crime, it was a tragedy. Don't let them turn my family tragedy into a crime. When I'm done speaking to you, the state gets to get up and rebut all that I've told you. They've got to have the last word, so to speak, because it is 100% their burden to prove to you that I committed a crime. And you won't be allowed to hear from me again. So I want you to remember that it is the state's job to prove to you that I committed a crime. And if you have not seen the evidence that leaves you firmly convinced that I have committed this very crime, then the state failed to show you the evidence that you need. Because I did not commit this crime. The only interview the state entered into evidence is mine. So I encourage you to go watch it. I told you just what happened that day, just the way it happened. The state put forth a bunch of evidence in this trial in an effort to make you dislike me, to try to attack my character, so that you would just say guilty no matter what evidence they showed you. But only you get to decide. The state put up witnesses that had zero knowledge of a conspiracy. The state did not show you evidence of an agreement to commit murder. They showed you evidence of a family tragedy, and then they showed you the sad effects of a family torn apart because of that tragedy.
All right, the state does have the burden, so they have the right to open and close the argument. Do you want to give a rebuttal close? Go ahead.
The execution of Charles Vallow is not a family tragedy. There is nothing that you can say about shooting a man as he lay on the ground that you can try to construe in any way to make that a family tragedy. This case is about the defendant, not Alex Cox. Alex is involved in it because that is her co-conspirator. We are not here to determine his guilt, albeit it is quite obvious. This defendant wants you to just look at one piece, and she wants you to hope that there's only a person who will say, I saw, I heard the conspiracy. But what did you hear in every instruction is that you can look to other evidence to show that. This defendant wants you to forget about her words and pretend that when she told her lover, her soon-to-be husband, we got rid of him, that he changed the life insurance before we got rid of him, that somehow means what? That they killed him. And he changed his life insurance before they killed him. What does that tell you? That tells you motive, and that tells you who did it. This defendant is one of those we because she's writing it. She wants you to pretend that when she is talking about Charles for months, acquiescing and agreeing to her brother killing him, having people tell her that it's wrong, having people know that they're planning something, that those words don't mean exactly what they are. We got rid of him, this defendant. The state, of course, has the burden, and that's how it should be. But every one of those justification defenses falls short when you look at the conspiracy itself. When they got rid of him, they did it by planning it. There is no reason that Alex Cox came over to this defendant's house with a loaded gun and waited for Charles to come inside, held there by this defendant using the cell phone. That is conspiracy. That is planning. That is premeditated. You can absolutely watch that whole video. That's why the state included that for you. What you're going to see is that Lori Vallow doesn't cry. She is not truthful, as we've gone through. Her timeline is absolutely wrong. She tells the detectives it's quick, it's 12 minutes. She wants you to believe that the police could understand all of this that day. But what did you hear? Is that all the police could tell initially was that the timeline was off. And then they started learning that the physical evidence seemed to be showing that Charles was executed on the floor, but they needed to see if the medical examiner agreed with them 2 days later. And then they needed to pull all those iCloud accounts, phone records, and go through terabytes of data to bring forth these things that you have now learned and hold. They interviewed these people who learned of the defendant's religious beliefs, that she was exalted, that she was celestial being, that she didn't have to repent. Of course she thought she was Nephi. We learned that the physical evidence on Charles and at the scene show us that he was executed. And every single one of those defenses that the defendant has asked you to look at, the state has met its burden. Because even if you somehow believe that Charles actually had that bat and it wasn't staged like the rest of the scene with the shoes and the lack of blood there, that second shot is not justified for self-defense, crime prevention, or third-party defense. Arizona law does not allow you to execute a man on the ground. The defendant wants you to believe she was shocked and surprised by this, and yet she goes wandering around, goes to Burger King, Walgreens, drops off her kid, comes back and jokes about her neighbors. Not one action of a person shocked, surprised. She wants you to feel bad for her daughter, Tylee. You saw her there. You heard from the detectives. She's also not shocked, crying, upset, worried. And you saw Alex. Same demeanor. Why? They've had 47 minutes to work it all out. Go through Charles's phone, figure out what they're going to say. They've talked on the phone twice in this time period. This case relies upon all of the investigation that the police did. That day, when they knew that timeline was wrong, that day when they started to understand that the physical evidence at the scene was staged and wrong and didn't match what the defendant was saying, and then all of the evidence after that, culminating when this defendant told the man that she married later that she was having an affair with as many times as she wants to say Charles was my husband. She didn't want him as her husband. She wanted Chad Daybell. She wanted that life insurance policy, and yes, she was angry about it. And she said, we got rid of him. That is her confession to you. That is why she is guilty of conspiracy to commit first-degree murder. Thank you.
All right. Do we have Izzy coming over? Izzy to be sworn in? All right, members of the jury, there are 14 of you, only 12 of you can deliberate. At this time, we're going to choose the alternate jurors by random lot here. So we have our scientific method here of random numbers.
14.
Juror 14.
Five.
Juror 5. I don't think you're 5. Well, maybe you are. Okay, so to the alternates, if I don't see you again, I want to thank you for participating in this process. The admonition still applies to you until we call you and tell you that it's been lifted. I have in the past had to have callback alternate jurors to testify or to deliberate when, for whatever reason, one of the jurors can't continue to deliberate, becomes sick, has a family emergency, et cetera. So you still could have to deliberate in this case. But again, if I don't see you again, I really do want to thank you for participating in this process. I know it might be somewhat of a disappointment to not deliberate right now, but we will keep you posted and we'll let you know if we need you. The remaining 12 jurors will retire to the jury room and begin your deliberations. First, we're going to swear in my staff.
Do you swear that you will take charge of this jury and protect their deliberations from all outside interference and communication, and when they have reached a verdict, you will bring them back into court without revealing the verdict to anyone, so help you God?
I do.
Thank you.
Izzy, drop those off. Undrop those off.
All rise to the jury.
Yikey, yikes. Hey, Rosebud, you're back. So the jury has it now. They just sent the jury out with their verdict forms, and the verdict clock just started. Verdict clock just
The
started.
jury's no longer present in the
3
courtroom.
seconds.
I've passed out proposed aggravation phase jury instructions in the event that there is a verdict of guilt. The state elects to proceed with an aggravation phase of this trial. So I'll let the parties review that. It's not too long.
I could just start to stick up on page 3. That's as a preamble.
Got it. All right, we'll be at recess until we hear from the jury.
All right.
Let me go take a look at Twitter real quick because I know that. Oh, wow. Hold on. 14 minutes ago, Kathy Russin posted. Hold on. Says, wow, the jury opted to go home. It's only 3:30 there. They will resume deliberations tomorrow. Well, I guess. Yeah, Nate Eaton posted 21 minutes ago. The jury wants to go home. We'll be back tomorrow. Crazy. They'll return at 1:30 p.m. Eastern Time. Tomorrow will be on a 5-minute delay ordered by the judge for tomorrow. So, all right. Well, it looks like what we will be doing. Sorry, I'm falling down the Twitter rabbit hole here. You know how that goes, right? Redo the poll. Okay, hold on. Let me redo the poll real quick. Hold on. Let me go end it. Sorry, you guys. Because I don't think I can edit it. No, I can only end it. Karen Reed does start tomorrow, Rosebud, as far as I know. Let me end the poll. It is early to go home, right? 40% of you said they'll have a verdict tonight. I guess they won't, will they? Hold on. Let me make a new poll. Hold on. Okay, now let me put the options in. Okay. And then all right, now go vote again. Vote, 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 vote. Vote, 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 vote. Tracy says, I'm food motivated and would have stayed for dinner and said guilty. Yeah, right? I know. Yeah, as far as I know, Karen Reed starts tomorrow. That's going to be my plan. I'll keep an eye on Twitter and stuff to see what happens. Um, but that'll be the plan, man. That'll be the plan. And I want to go back and look because the last I heard, Stephen Stern's attorney was trying to delay or continue or something the hearing that's coming up. But I don't know if they did or if they denied that, if the judge denied that. I don't know. So, now here's the thing, okay? Karen Reed's trial is going to last a bit. That's going to last like 4 to 6 weeks or longer. Right? Stephen Stern's trial starts May 5. So for the Karen Reed fans, probably going to have to end up stopping that coverage because I'm here to watch Stephen Stearns go down. Just so you know. Being honest. Rosebud says I won't be watching Stearns. And I understand that. I totally understand that. Some people, I've heard a lot of people say that. Spins, ma'am. His is supposed to start May 5th, but, it'll probably be 2 or 3 days after that because unless that they start picking a jury earlier, I don't know. Usually, so it would be the 5th would probably be when they begin jury selection, but I'm not sure. Too triggering. I get it, Rosebud. I understand. A lot of people feel that way, and I can't blame you, Oh, I'm going to be streaming that one and the murder trial. So, boom. Cynthia's like, I'm absolutely going to watch Stearns. I'm here for it. I'm here to see his little gnarly butt show up in court. Ugh, he's disgusting. He's a disgusting creature. Ugh. Yeah, Sherry. His parents already know a lot, but I'm sure they don't know everything, But his parents know that he's a Pedialyte. Tracy says, okay, I'm going to kind of watch it, but I've been watching Reed, so I guess I should finish that out. Yeah, I know. And that's the hard part whenever I try to, and I've done 2 streams at once. What was it we streamed? We streamed Chad Daybell, and what was the other one that we streamed at the same time? I don't remember. But I did. We double streamed. I mean, it's possible I could do it. I just can't um you know. Oh, was it the fire pit one? Sherry and Miss King both same time. Fire pit murder. Fire pit mom. Okay. No, it wasn't Sarah Boone Rosebud. The Chad Daybell was way back. Um Spence says, Jenny, I was kidding. But no, seriously. I mean, I could. It's nerve wracking. You know, I don't know. I don't know. Melody Ferris. That woman. Good grief. All right, you guys. I'm going to get out of here, but wait. I got to end the poll. End the poll. If you haven't voted, you got about 3 seconds. We got 10 votes. Okay. The cool judge. Yeah, we like that judge. All right. Ending the poll now. And you guys say the question was, how long will the jury deliberate? And 60% of you said tomorrow by lunchtime. And 40% said late tomorrow evening. So, nobody thinks it'll take 2 or more days. Okay. We'll see tomorrow. We'll see tomorrow. I would hope, because I'll keep my eye out on the verdict. But obviously it'll be after 2 p.m. Eastern time, right? So somebody asked what time it was there a while ago. Who was that asked? Where is it here where I'm at, or what time is it where who was that asked? Okay, Rosebud. So Rosebud, did you want to know what time it is here for me in my time zone, or what time it is where Lori's at? For me, I'm on Eastern time. So it's 7 p.m. for me. However, Lori's 3 hours behind. So it is 4 p.m. for her. Okay. And both Stephen Stearns and Karen Reed will be in Eastern time too. Okay, so it's 6 p.m. for you right now, Rosebud. Right? Right. 6 p.m. All right. I'm going to get out of here, but I'll be back in the morning for Karen Reed's opening statements, and as long as they're going on with it. So, and then we'll keep an eye out for the verdict tomorrow, and hopefully it'll land at a time when they're like on lunch or something. I don't know. Hope you come hang out with us again tomorrow, Tracy. Everybody, y'all. It's been fun today. And I'm going to go. I'm going to go get some dinner and get kiddo ready for bed. And I'll be back tomorrow. Make sure that you guys hit the thumbs up before you leave if you haven't already. If you've fallen over to this part of the YouTube world, I would love to invite you to stay and subscribe. Click the notification bell so you don't miss anything. And if you're watching this later, please put a hashtag replay in the comments down below so I know you're watching on the replay. Okay? You should be able to come in and out. All right. Sounds good. Hope your belly's feeling better. All right. I'll see you guys tomorrow. Bye.